distinguished guests, ladies and gentlemen, on behalf of IMH and sponsors, and as the chair of this event, I would like to warmly welcome you to the second conference entitled the Cyprus Annual Legal Conference, and thank you all for attending in this digital format. I would also like to thank our eminent speakers and panelists for having accepted our invitation tonight. I will introduce each of them, each speaker and panelist in turn throughout the event. The main topic of today's annual event is both extremely timely and valuable. In the wake of COVID-19 and the rapid digitalization of the business world, what is the current status of the legal industry? I'm happy to see that the topic has fully invited itself into this virtual conference room. All of us have the opportunity today to interact through the platform, which offers, first of all, a downloadable agenda, which I think you all have, a clickable sponsor logos directing you to relevant websites, and the opportunity to submit your questions to the speakers throughout the event. To do this, please type in your questions in the QA window and click submit. Now, it's time to embrace our topic of the day. By way of introduction, I'd like to make the following remarks on the vital importance of the legal sector for the economy. In the latest EU Justice Scoreboard, published in June 2020, the following indicators of an effective justice system were used: efficiency, quality, and independence. The report relies on multiple studies showing that effective justice systems that uphold the rule of law have been identified as having a positive economic impact. Findings include a positive correlation between the perception of independent justice and foreign direct investments, but also growth and productivity. Amid the COVID-19 public health crisis, Dr. Klearchos Kyriakidis and myself initiated the rule of law monitoring mechanism for Cyprus and beyond. Its formation was motivated by a growing concern for and determination to protect the rule of law, the proper administration of justice, human dignity, and fundamental freedoms and rights. These and so many other characteristics of a democratic society are at risk of being adversely affected amid the coronavirus pandemic and any other crisis of comparable magnitude. As for its thematic coverage, the rule of law monitoring mechanism revolves around the operation of the rule of law in the Republic of Cyprus, particularly on the eve, in the midst, and in the aftermath of any grave crisis, including the pandemic. In this context, and given its preoccupation with time of crisis, the rule of law monitoring mechanism and many other similar initiatives seeks to explore a series of fundamental questions of high relevance to the legal industry and of today's topic. These questions include whether the rule of law is safe or unsafe, to what extent are public bodies, private bodies, and individuals upholding under or undermining the rule of law? What is the proper role of judges, lawyers, legal academics, and law students? How lawyers may fulfill their ethical, professional, legal, and other duties while simultaneously protecting their physical health, mental health, and overall well-being. How and when, and by which means, may justice be delivered in response for any injustices allegedly caused by or during the crisis? Finally, can any lessons be drawn from the coronavirus pandemic and any other past or ongoing crisis? All these questions are at the heart of today's proceedings, with a particular focus on legal challenges such as force majeure and hardship, professional development, digitalization and innovation in the legal profession, clients' expectations, employment and the economy, human rights in the business relations, compliance and risk assessment, and the future of the legal sector. We are particularly grateful to their excellencies, Mr. George Savvidis, Attorney General of the Republic of Cyprus, Justice Stelios Nathanail, President of the Supreme Court of the Republic of Cyprus, and Ms. Emily Iolidis, Minister of Justice and Public Order of the Republic of Cyprus, for their views on the future of the justice in Cyprus. Before starting the first session, I think I have to invite you to watch a short video on how to navigate the platform during the conference. Yes.
Welcome to IMH Digital Events. For the best browsing experience, just select one of the icons to see the conference program, to read material from the sponsors, to learn more about today's speakers, to submit a question, and to browse IMH Media. Click on the sponsors' logos to learn more about their products and services.
Thank you to the organizers for this. Let me first welcome our first speaker of the day, Ms. Holly Stebbing, partner at Norton Rose Fulbright LLP in the UK. Ms. Stebbing will develop the topic of force majeure in business within the next 10 minutes, please. Q&A will follow at the end of the session. Thank you very much.
Thank you very much, and thank you for inviting me to present to you today on the unprecedented business disruption caused by the COVID-19 pandemic. As Stephanie said, we only have 10 minutes, so I do not plan on going into too much detail, but instead we'll focus on the key points you need to keep in mind when dealing with issues caused by COVID-19 in English law contracts. I will take questions during the Q&A slot, but given the tight programme, I'm also happy to take any follow-up by phone or by email. So going back to law school briefly. Oh, let me just push the slides. There we go. Going back to law school briefly, English law generally holds parties to their bargain, even where subsequent events make performance of the contract much more difficult, expensive, or onerous. The policy reason for this is that parties have freedom to contract and therefore to allocate the risk of supervening events affecting performance between them. The only exception to this is the narrow common law doctrine of frustration. If a contract has become impossible or illegal to perform, it is said to have been frustrated, with the consequence that it is automatically discharged without the parties having to take any further steps. It is not enough that a contract has merely become more expensive or onerous to perform than originally envisaged, and consequently, it is unlikely that the impacts of COVID-19 on business, most of which have not made performance entirely impossible, but simply more onerous, will be sufficient to demonstrate frustration. To deal with the narrowness of frustration, parties use force majeure clauses to widen the circumstances in which they will be relieved from contractual performance if unexpected events occur, and also to set out the consequences which will follow. The essential point to remember from an English law perspective, unlike some other jurisdictions which will no doubt be touched on today, is that force majeure is a creature of contract. That means that the circumstances in which you can claim force majeure and the consequences which follow will depend entirely on what is said in the clause and not on any general principles of law. It is therefore very important to carefully study the contract wording before making or responding to a force majeure claim. Naturally, that's not always been easy for businesses trying to make time-critical decisions in the midst of the current crisis. So let's take a quick look at the key elements of force majeure. First, check that there has been a qualifying force majeure event. Some contracts include an exhaustive list of specific events. And in the COVID-19 context, we're looking for wording such as pandemics, epidemics, travel restrictions, and/or government acts, all of which are commonly seen in force majeure clauses. But I've also seen claims relying on less obvious wording, such as natural disasters and acts of gods. Other contracts are wider, covering any event beyond seller's control, which will make it easier for you to bring your COVID-19 impact within the ambit of the clause. When making a claim, it's important to consider what has actually prevented performance and whether that falls within the contract definition. Is it the virus itself and therefore epidemic, pandemic type wording, or is it in fact the regulations which have been implemented to close businesses, ports, and restrict freedom of movement, which I found is more often to be the case? Once you have identified the force majeure event, check what standard of causation applies. Some clauses are narrow and only provide relief if performance is entirely prevented. Others are more generous and include where performance has been hindered or delayed, and are therefore easier to invoke for COVID-19 impacts. For example, where there have been delivery delays as a result of COVID-19, but delivery has not become impossible. Always make sure that you comply with the notice requirements of the contract, as failure to do so may mean that you're not entitled to relief. We've seen this cause problems recently where offices have been closed and postal services disrupted. Finally, if you want to make a force majeure claim, document your decision making. Force majeure claims are often litigated, and having a paper trail is the best evidence that you're entitled to relief. It is not always so easy to piece that together after the event. So what are the consequences of claiming force majeure? Again, this will depend on the drafting of the clause, but the most common consequence is that the contract is suspended and one or both parties are relieved from performing their obligations for the period of the force majeure event. Another form of relief is termination. Depending on the drafting, termination can either arise as an automatic consequence, or it can be at the option of one or both parties after the elapse of a period of time. It is worth thinking about whether you really want to invoke a force majeure clause when it could give rise to termination of your contract. And in rarer cases, the contract will allow the affected party to claim financial compensation from the non-affected party for costs associated with the FM event. And we've seen claims for additional costs of performance arising out of the need to use PPE and to maintain social distancing following the coronavirus outbreak. A word of caution on force majeure claims: incorrectly calling a force majeure event and then failing to perform your obligations under the agreement could lead to unintended consequences, including repudiatory breach of contract, meaning that your party could be entitled to terminate the contract and sue you for damages. So take care. It's increasingly common to see clauses in contracts which seek to allocate the risk of change in law to one or other of the parties. Oh, I think the slides may have jumped on. There we go. These are usually included in contracts which are long-term and where changes in the regulatory landscape are a possibility. So, for example, we often see them in public-private partnership contracts, long-term energy contracts, and contracts with states and SOEs. Much like with force majeure, the key to claiming change in law is to carefully step through the contract clause to establish whether you're entitled to claim relief. First, check that you as a party can claim change in law relief. It doesn't always apply to both parties to a contract. Equally, it may only apply to changes in law in specific jurisdictions. For example, in the construction context, the country where the infrastructure is being built may be covered by the change in law relief, but changes in law in other jurisdictions will not be. This has caused some supply chain impacts on construction projects that we've been advising on. You'll also need to look at the definition of change in law. Problems have come up with COVID-19 where some governments have chosen to issue guidance rather than legislation to try to control coronavirus. And this does not qualify as change in law under the contract, but nonetheless impacts one party's ability to perform. Issues have also arisen where there is an obligation in the contract for a party to act in accordance with good industry practice or as a reasonable and prudent operator, and an industry body has issued COVID best practice, which that party then has to follow in order not to breach their RPO obligation. But the industry guidance does not amount to a change in law, and therefore they do not get any time or money for the change in practices that they've had to make. Most change in law clauses will provide that the party should negotiate amendments to the contract to deal with the change in law, potentially providing the affected party with time, money, or some other form of relief. Moving on then to the final form of clause which we've seen been invoked in response to coronavirus, material adverse change clauses, which are often used in M&A SPAs to protect the buyer from the risk of unexpected events arising which impact the target between signing and completion. Again, these are creatures of contract, and the circumstances in which they can be invoked will depend on the specific drafting. Material adverse change claims are notoriously difficult and often fail. The public policy favours enforcement of signed contracts, and the courts will only allow you to exit a deal where you fall squarely within the scope of the material adverse change clause. So key points there to bear in mind are whether you have a qualifying material adverse change. This will usually be quite specifically defined in the contract. The question of whether that change is material will depend on the circumstances, but generally speaking, the evidential threshold is very high. The material adverse change must have occurred during the interim period between signing and completion. So timing is very important and can be quite complex in COVID cases. You must then be able to demonstrate a causal link between the change and the adverse impact on the target, rather than it having been some other event which affected the target's performance. Changes to the economic market generally are not sufficient unless the MAC clause specifically includes them. I think generally speaking, COVID-19 will not amount to a material adverse change unless pandemics or government acts are expressly included in the clause, and you can demonstrate the necessary degree of causation that will be required. Having said that, there are already a few MAC cases making their way through the courts, the Travelport and WEX litigation here in London, and several cases I've seen publicised in the US. This slide just highlights some of the other clauses that you should check for in your contracts, which may provide alternative forms of relief where your performance is impacted by COVID-19. And then finally, I couldn't speak today about how contract mechanisms can be used to address COVID-19 impacts without very briefly looking at the interventions which governments have made via legislation to curtail the exercise of some of these rights. I was interested that Stephanie started by talking about whether the rule of law is being upheld during coronavirus. And I think certainly in this country, some of the changes to legislation and some of the legislation that's been implemented has raised some eyebrows. In the UK, we've had the new Corporate Insolvency and Governance Act, which recently came into the force, which, as well as overhauling our insolvency regime, also prevents companies from terminating supply contracts with counterparties in financial difficulties, thus removing one form of contractual relief for non-performance. Similar legislative measures have also been introduced in other major global economies. In Singapore, for example, the COVID-19 Temporary Measures Act has been enacted, which provides temporary relief to businesses unable to fulfill their contractual obligations. And I understand that in Cyprus, there are now statutory limits on calling in loans by lenders. I'm very conscious of time. I hope that was a helpful run through at quite a quick pace of the key contract mechanisms which we have seen being considered and evoked in response to COVID-19. Thank you.
Thank you so much, Holly. Thank you so much for sticking to the time, first of all, and being so clear and I think very, very helpful. Now, you would be happy to know that we have over 170 participants currently watching. So I'm sure there will be questions. I have a few for you in any case. Thank you very much. Now, I'd like to introduce our next speaker, who is Mr. George Campanella, partner at Bivonas Law LLP in the UK, who will develop the topic of innovating talent management in law firms and the need for capable lawyers and future partners. Again, 10 minutes, George, and the Q&A will follow at the end of the session. Thank you.
Hello, a very good afternoon to everybody. Can I just say that when I received the invitation to speak at this second legal conference, I was very happy to accept. It's always a pleasure helping. What I'd like to do today is obviously highlight what has been happening in the world recently as a result of COVID-19. I haven't met anyone who has not actually been affected by the virus. I think it's affected everybody in any situation they find themselves in. What I'd like to do today is focus predominantly on talent, talent in legal firms, in law firms. I think it's a very important aspect of this conference today, because what talent produces are professionals in the future. And if you don't have good talent, it has a knock-on effect on everything. Talent produces lecturers, university leaders, it produces judges. So if you don't have the correct talent on board, there could be problems in the future. I have a set of slides, and what I will do is, as I'm speaking, I will introduce each slide in turn. The first slide is obviously the subject, which is talent and management in law firms. Just to briefly tell you a little bit about myself, I have 22 years experience in the legal profession, and over the years I have seen a lot of rapid changes. The change which has affected everybody in the legal profession is obviously COVID-19, and as a firm, we, and I'm sure other firms have in any part of the world, have been looking at ways of dealing with the change and adapting to the current climate. Now, that's not an easy thing to do, because it's right to say that COVID-19 is unprecedented. There have been small outbreaks in various parts of the world of various diseases, but COVID-19 is unprecedented and it's widespread. It's all over the world. The biggest problem that COVID-19 has created is obviously impacting law firms, not just law firms. And I am aware in this conference today that there are professionals from different walks of life. So what I'd like to do is I'd like to speak about the impact with regards to other professions, not just law firms, because I think it applies to everybody. If we just turn to slide 2, impact of COVID-19 on law firms. Sorry, it's jumped ahead a little bit. I want to talk a little bit about restructuring. Sadly, many firms have had to make very difficult decisions. That's meant laying people off, making people redundant, which means in turn there are less people on board. That means there's less talent available in-house. This presents an opportunity, however, for a pool of high caliber persons looking for positions. So technically speaking, we've gone back to square one. There are people looking for jobs, and some of these people are very talented indeed and would be an asset to any firm. How firms actually deal with restructuring depends on their business model, how they've evolved throughout the pandemic. The difficulty you have with recruiting individuals is you don't have face-to-face meetings with them. Just like clients, you don't have face-to-face meetings with clients. I think it goes without say that everyone will agree with me, it's not the same anymore. COVID-19 has impacted on the way we conduct our business. We're getting used to the virtual world, and in turn, it's become a huge game changer for us all. Well, face-to-face is possible, but we all have to exercise a certain degree of caution, because we need to look after everybody in the workplace, our families, our friends. So obviously, if we're going to have face-to-face meetings, they have to be with extreme caution, and you have to obviously follow government advice and guidelines. Insofar as my area of law is concerned, I practice white-collar fraud, and I have actually seen a huge impact on a backlog of cases. They are slow, they're not progressing. In fact, there are some statistics that suggest that almost 483,000 cases in the United Kingdom were waiting to be dealt with by the 17th of May. And that was due to the United Kingdom's lockdown. And I had a look online earlier on, and I was astounded that things just do not appear to be moving. And the backlog is immense. I have a trial which has been scheduled for March 2022, which is an awful long way away. In fact, that touches on a very important point, which Stephanie kindly mentioned during the opening of this conference in regards to the rule of law. That affects the rule of law, because if these cases are not going to trial, it's not just the person who's accused of the offence that suffers, but also victims. And that has a huge impact on the rule of law generally. Going back to law firms and any other profession, obviously it's going to be very difficult for them to make commercial decisions. If you're going to make a commercial decision, it's going to be delayed due to the uncertainty of the economic climate we find ourselves in at the moment. And that affects recruitment, it affects expansion, and it also has a knock-on effect on your staff because it unsettles everybody. People become rather weary about their position. They are worried whether they're going to receive an email saying they no longer have a job because the firm is struggling financially. So it's very unsettling for staff. And what I would say is it's quite important that this is dealt with very early on, because what you don't want is a situation where your staff don't have any more enthusiasm to work because they find themselves in a position where they are worried about their future. So I think it's very important to maintain very strong ties with your staff, even if they are working remotely. In fact, it's never been more important. If we could turn to slide 3. I'm not sure if anybody is familiar with this book, but I must say I found it immensely inspiring. It's a book which has been written by Tom Collins. The title reads From Good to Great. And I think anybody that's recruiting, especially in the current climate, should read this book. And what I have done is, because there's not much time, I've taken a couple of extracts from the book, and I will also give you my overview about what Mr. Collins has said in his book. What he says is, and then obviously we've got to consider this in the light of recruitment and talent. First, get the right people on the bus, the wrong people off the bus, and the right people in the right seats, and then they figure where to drive it. What we have to remember is not everyone is a leader. Leadership is important in the legal profession as it is in any other. So it would not work to place a leader, to actually place a leader at the back seat of the bus, because you wouldn't get very much out of them, unfortunately. All you would receive is discontent, which is not good. So you would need to hire the right people and take the mistakes from the bus fast. It's rather like fine brandy. Your team has to be distilled over time. So we all must think very carefully what type of talent you need in your team. Think about not just about their expertise, their client following. You have to think very carefully about the person fitting into your environment, because your environment is your livelihood, it's your firm, and you want it to succeed. If we could move to slide number 4. The impact on COVID-19 with regards to recruitment continues despite relaxation of the lockdown. I think one of the difficulties a recruiter would encounter is in relation to remote interviews. They're not the same. Once you've decided on the people that you need, the recruitment process is somewhat different to the traditional ways that we hire people. In most cases, you are no longer able to interview somebody face-to-face. And it has its disadvantages, because when a person is being interviewed, you often consider body language, which you can't necessarily ascertain from a camera. It does have its advantages because you're able to interview more people, and also there are situations where the interviewee, the person you are hoping to recruit, is in a far more relaxed environment than he would be if he were face-to-face with you. Summing up, COVID-19, it appears it's here to stay for some time yet to come, I would say. We all hope that a vaccine will be available soon, but it's a reality that we all have to deal with. So we all have to focus on talent. I think it's very important. And as I said earlier on, it does have a knock-on effect on the quality of people who filter themselves through the legal system. A lot of businesses have suffered. And I think really innovation is what we have to look at very carefully. We've got to look at innovation more than ever before. It's absolutely vital. I am happy to take any questions during the questions and answers session, and I hope you enjoyed my discussion. Thank you.
Thank you very much, George. Thank you for your, well, it's really a personal, journey into this crisis. I'm sure it will raise also some questions, some interesting questions. We now have a 5-minute Q&A session, followed by a very brief 5-minute comfort break or coffee break. So I will invite all delegates to participate to the discussion by using the platform. I have a question already for Holly. So I don't know if we can also show Holly on the screen, or if you see Holly on the screen and George. I can only see George for the moment. Holly, there is a question which is quite technical, and actually I had a quite similar one for you. So that comes from a participant. As a result of COVID, many governments enacted specific legislation or regulations, as you have mentioned. Do you agree that such measures can also come under the change of law clause, which may give rise to compensation or damage, or damages, I suppose, as a result of the change of law? These, depending upon the contract, may be more beneficial than a force majeure clause that may allow a suspension of the time for performance, and therefore invoking both may give rise to compensation or damages under the change of law clause as well as under the force majeure clause. Holly, do you think you could address this in a couple of sentences?
Yes, no problem. Well, thank you for the question. And actually, it isn't the first time that I've been asked that question since this crisis started. I think one of the surprising factors for a number of clients is this interaction between force majeure clauses and change in law clauses, that there may well be circumstances in which you're entitled to relief under both. So whereas I think people had traditionally thought that a type of force majeure event, unexpected event, would only give rise to time under contract, when you then factor in the relief that you're entitled to under a change in law clause, you may well also be entitled to money. And the two aren't mutually exclusive, depending, of course, on the wording of the contract. So yes, you may well be able to claim both and therefore benefit from time and money.
Thank you very much, Holly, for being, brief and clear. Actually, I have a follow-up question for you from me, and then I have one for George, because I haven't been given other questions anyway. So what do you think your advice could be in case of public health disasters in the wording of the force majeure clause? I heard you saying at the beginning that we have to look for keywords such as pandemic, and then you actually said that a lot of contracts don't have those keywords, but they have acts of God, obviously. So what could be the advice to the professionals in drafting such clauses? Do they have to be very specific and refer to all types of public health disasters or even names such as COVID-19, or are we able to work with a broader clause in the contract?
I think the perfect solution, if there ever can be one, is to have the list of specific events, which would include public health type emergencies. And the note of caution I would give in relation to a pandemic is obviously it took the WHO until the middle of March to declare coronavirus a pandemic, which meant that people who had clauses that just referred to pandemic weren't entitled to relief necessarily until that date. But if you have the list of specific events and then the sweeper up wording at the end, which says, and any other event outside that party's reasonable control, that's probably casting the net as widely as you can, assuming you're the party looking for relief. I just make one other point. As a matter of English law, at least, it's not a requirement that the force majeure event is unforeseeable. Therefore, unless there's explicit foreseeability wording in the clause, you may well still be entitled to force majeure relief, even where the event was foreseeable. I think that's important in the context of coronavirus and related outbreaks, because of course, from now on, when people are entering into new contracts, you can fairly say that coronavirus is reasonably foreseeable. Even though English law may well entitle you to relief in those circumstances, my advice would be to include express wording to say any other event beyond that party's control, open brackets, whether or not foreseeable, just so that you don't get into that debate about the fact that this, at the point of signing the contract, this was an event which could reasonably have impacted performance.
Thank you very much, Holly. I think that's very helpful. George, I had a question for you, which is more of a guess, really, but I wanted to ask you whether you have seen a change in the management style and the leadership of law firms in the UK. And you mentioned the word leadership at the end, actually.
I have seen a change. I think a lot of people are taking a lot more precautions as to who they decide to recruit. Leadership is important at the end of the day because leadership is productive. And I've come across a number of colleagues who have often spoken to me recently virtually, because obviously a lot of people don't have the confidence meeting face to face just yet. But I have seen a change. I think there's a lot more caution. I think people are looking for individuals who are of greater caliber than they have been looking for in the past, because I think the higher the caliber, the more likely it is that a firm will get through this pandemic. And the stronger you are, the cleaner you will come out of this pandemic at the end of the day. So I have seen a change, and it means a lot of caution when making any decisions about who to take on.
Thank you very much, George, for this. So I'd like to thank the two of you for accepting our invitation and giving your insights into, very important professional issues. Your contributions were very valuable, and we invite you to stay with us for the rest of the proceedings. For the moment, we will have a very, very brief coffee break. You should be back in 5 minutes online. Thank you, everyone.
Thank you.
Thank you very much.
Οι σπουδές ανοίγουν το δρόμο για το δικό σου αύριο. Εδώ ξεκινάει η πορεία σου. Χρειάζεσαι σωστή καθοδήγηση και ενδυνάμωση. Να εξοπλιστείς με τις πιο σύγχρονες μεθόδους μόρφωσης. Χρειάζεσαι να προετοιμαστείς σωστά. Να χαράξεις στέρεους επαγγελματικούς δρόμους και να νιώσεις πως ανήκεις. Στο Πανεπιστήμιο Euclid Cyprus ανοίγει η πόρτα για το δικό σου μέλλον. Με 2 πτυχία από Βρετανία και Κύπρο εξασφαλίζεις ένα αύριο όπου όλα είναι δυνατά. Πανεπιστήμιο Euclid Cyprus, το Βρετανικό Πανεπιστήμιο της Κύπρου.
Κάθε μέρα κάνουμε μικρές κινήσεις για να προστατεύσουμε τους εαυτούς μας και τους αγαπημένους μας από τυχόν κινδύνους. Οδηγούμε, σερφάρουμε στο διαδίκτυο και δουλεύουμε με ασφάλεια. Έτσι συμμετέχουμε στο στοίχημα και τα τυχερά παιχνίδια. Με ασφάλεια. Τώρα έχεις την ευκαιρία να μάθεις τι είναι το ασφαλές παιχνίδι για να βοηθήσεις εσένα και τους γύρω σου. Εβδομάδα ασφαλούς παιχνιδιού 5 με 11 Οκτωβρίου. Εθνική Αρχή Στοιχημάτων. Let's keep it a game.
Οι σπουδές ανοίγουν το δρόμο για το δικό σου αύριο. Εδώ ξεκινάει η πορεία σου. Χρειάζεσαι σωστή καθοδήγηση και ενδυνάμωση. Να εξοπλιστείς με τις πιο σύγχρονες μεθόδους μόρφωσης. Χρειάζεσαι να προετοιμαστείς σωστά. Να χαράξεις στέρεους επαγγελματικούς δρόμους και να νιώσεις πως ανήκεις. Στο Πανεπιστήμιο Euclid Cyprus ανοίγει η πόρτα για το δικό σου μέλλον. Με 2 πτυχία από Βρετανία και Κύπρο εξασφαλίζεις ένα αύριο όπου όλα είναι δυνατά. Πανεπιστήμιο Euclid Cyprus, το Βρετανικό Πανεπιστήμιο της Κύπρου.
Κάθε μέρα κάνουμε μικρές κινήσεις για να προστατεύσουμε τους εαυτούς μας και τους αγαπημένους μας από τυχόν κινδύνους. Οδηγούμε, σερφάρουμε στο διαδίκτυο και δουλεύουμε με ασφάλεια. Έτσι συμμετέχουμε στο στοίχημα και τα τυχερά παιχνίδια. Με ασφάλεια. Τώρα έχεις την ευκαιρία να μάθεις τι είναι το ασφαλές παιχνίδι για να βοηθήσεις εσένα και τους γύρω σου. Εβδομάδα ασφαλούς παιχνιδιού 5 με 11 Οκτωβρίου. Εθνική Αρχή Στοιχημάτων. Let's keep...
Οι σπουδές ανοίγουν το δρόμο για το δικό σου αύριο. Εδώ ξεκινάει η πορεία σου. Χρειάζεσαι σωστή καθοδήγηση και ενδυνάμωση. Να εξοπλιστείς με τις πιο σύγχρονες μεθόδους μόρφωσης. Χρειάζεσαι να προετοιμαστείς σωστά. Να χαράξεις στέρεους επαγγελματικούς δρόμους και να νιώσεις πως ανήκεις. Στο Πανεπιστήμιο Euclid Cyprus ανοίγει η πόρτα για το δικό σου μέλλον. Με 2 πτυχία από Βρετανία και Κύπρο εξασφαλίζεις ένα αύριο όπου όλα είναι δυνατά. Πανεπιστήμιο Euclid Cyprus, το Βρετανικό Πανεπιστήμιο της Κύπρου.
Κάθε μέρα κάνουμε μικρές κινήσεις για να προστατεύσουμε τους εαυτούς μας και τους αγαπημένους μας από τυχόν κινδύνους. Οδηγούμε, σερφάρουμε στο διαδίκτυο και δουλεύουμε με ασφάλεια. Έτσι συμμετέχουμε στο στοίχημα και τα τυχερά παιχνίδια. Με ασφάλεια. Τώρα έχεις την ευκαιρία να μάθεις τι είναι το ασφαλές παιχνίδι για να βοηθήσεις εσένα και τους γύρω σου. Εβδομάδα ασφαλούς παιχνιδιού 5 με 11 Οκτωβρίου. Εθνική Αρχή Στοιχημάτων. Let's keep it a game.
Hello, welcome back everyone. And warm welcome to the second session of the conference. And I would like to introduce Ms. Cynthia P. Vaught, Chief Client Officer of Miller Nash Graham and Dunn LLP in the USA. Good morning to you.
Good morning.
Good morning. She will talk about delivering excellent client experience and the key to attracting and expanding work with more clients within the next 10 minutes, please. Thank you very much.
Excellent. Well, thank you very much for having me join your program today. It's a pleasure to be here. So delivering excellent client service is a particular passion of mine. I've been working in the legal industry for over 20 years. And in my current role, I oversee not just our business development area, but also our information technology, our legal support staff, records, really having a focus to how do we better serve clients. Because what we found in today's market, even before COVID, is that client expectations just continue to grow. And our ability as firms to deliver an excellent client experience is imperative to having success with them. Clients are feeling economic pressures, the likes of which they haven't seen before, both before COVID hit, but certainly now that COVID is here. Their dollars are even more critical to be spent responsibly. Law firms or clients also have tremendous amount of data available to them. So they know they have choices in law firms. They know they have choices in attorneys that they can hire. They also have more data available to them in terms of where they spend their money and how they can control costs. So what are law firms to do to make sure that they're delivering an excellent client experience and more value to their clients? In the end, this is a relationship business. Clients expect excellent legal work, but it is very, very critical for them to also receive exceptional service. They might not know the difference between good or bad legal counsel in some instances, but every client can determine whether they've received excellent client service or poor service. And that will have an impact on their choice of whether to hire you again or not. One of the things that we counsel firms on is to make sure that they're really focusing on their key clients. A lot of times there's a focus on new clients, which certainly is important to continue to bring in new clients. But the clients you already have are the ones who are giving you your revenue, and there's opportunity to expand your work and at minimum keep their work to ensure that you still have that revenue. So what are we to do? Adopting a client-focused mindset is key. A lot of times it sounds very simple, but basically putting yourself in your client's position of what is their experience when working with you or any of the professionals who work at your firm, and making sure that all of those touch points are very stellar, so that everybody's on the same page in terms of making sure that the client needs are being taken care of. It is also really important to know your client's specific business. So what are their top challenges of the moment? What are their top challenges that they're facing in the future? Do you have a great understanding of their company culture? So you might work within a specific industry, but each company has its own culture and its own challenges that it will be facing, and making sure that you're tailoring all of your strategic thinking along those lines is part of delivering an excellent client experience. Do you understand their definition of success? If you're taking on a matter or a transaction that you've done many, many times, your client is still going to have some specific thoughts about what they want out of it. So making sure that you have a good understanding of how they define success as you're taking care of their work. And how do they like to be communicated with? Everybody has a personal preference. And so making sure that you really do understand that you're not taking a one-size-fits-all approach to your client, but you're really being client-focused. Proactivity versus reactivity is another critical element of excellent client service. So making sure that you bring ideas to them as opposed to waiting for them to bring them to you. And it shows that you care and understand about their needs when you're being proactive. They need to trust you and know that you are working for their success. And so taking a proactive mindset instead of waiting for their phone call or their email shows them that you're really there to be a partner with them in their success. And it increases their sense of value when you do bring those ideas to the table. So another element of excellent client service is asking for feedback. So this is something that a number of firms do, but if your firm is not doing this as a regular practice, highly encourage you. This is one of the areas where you're going to drive the most revenue when it comes to your current clients and expanding work with them. So making sure from just an informal standpoint that you're having client conversations before a matter kicks off, making sure that you're really understanding, again, their sense of success, how they want to be communicated with, what their expectations are, making sure that communication is happening all throughout the matter that you're working on with them or the transaction, and then doing post-matter debriefs or post-transaction debriefs to ask how that went. Because the idea is that you'll be doing many more of those matters with them, and you want to ensure that you're continuing to build an even better client experience as you progress in your relationship with them. Formal client feedback programs are a different animal or a different approach than client conversations, ongoing feedback, but also highly recommended. It's found that firms that do have a formal client feedback program tend to get 1/3 more work from their existing clients. They also have a 35% higher client retention rate. Their clients are happier to stay with them because they know that their needs are being met. So formal client feedback programs typically involve firm management and other business professionals who meet with clients. In pre-COVID era, it would be in person. Depending on where you're at, maybe it still is. It could be through video conference. And those are conversations not about specific matters, but about how the firm is taking care of their needs. So that is asking questions about what is working really well in our relationship or for our professionals working with you. What else could we do to offer value to you? And that is an opportunity to ask about those top business challenges that they are facing down the road and bring that information back so firm management can bring that information back to the attorneys working with that client. And it can provide some excellent insights into how to strengthen the relationship and other work that could be done. I personally do client feedback interviews with our managing partner on a regular basis, and each one of those interviews has yielded additional work. As great as your relationships are with your clients, they don't always recognize the other services available from your law firm. And we have found time and time again that they ask to know more about what our firm can do to help take care of them. Because when they're very happy with you, they would like to give more work to the firms that they trust, the professionals that they trust, because they have a lot of pressures on them and they want to ensure that their pressures are as alleviated as possible, especially I think in this work environment when folks have even more that they're dealing with. So communication is another aspect. It is also a very more simple concept, but clients time and time again, one of their top complaints is that they don't get great communication from their law firms. So you want to make sure that you're putting a mindfulness to how you communicate with your client. Again, it starts with some conversations and really understanding their needs of how they want to be communicated with. Frequency, whether they want to have video conferences, in-person meetings, email, phone, texting. Some clients prefer text updates. So making sure that you're asking these questions, and if they are asking for regular updates, how lengthy do they want those? Are they going to be leveraging those into a board report? Should you give that to them as a PowerPoint slide that they can more easily slide into those reports? So there are a lot of different elements to communication that you want to make sure that you're exploring so that you're completely meeting their needs and not creating additional work for them. Also making sure that you're being transparent. If there is some negative turn of events, bad news does not get better with time. You want to make sure that you're being forthright with your clients and bringing whatever challenges are being presented to them as soon as possible. Again, it's about building trust, and it's making sure that they feel that their needs are your top priority and that they will be well taken care of. As you're having conversations, one thing that I think is really imperative is being able to listen. I think as experts as you are as attorneys, you're paid to be giving advice on a regular basis. When it comes to a client-centric approach, listening is key. So making sure that you're asking open-ended questions about their business and then taking time to listen. There is tremendous amounts of information and frankly work opportunities that come up when you give the space for the client to talk about their business and their needs and their concerns and the challenges that they're facing and what's keeping them up at night. And in the end, you want to make sure that you have a full understanding. And so that listening element is critical. I would be remiss in talking about communication if I didn't also mention responsiveness. I think, again, in this era of information and immediate response, clients expect responsiveness. And we all have a lot on our plate and more pressures than usual. If you're taking care of kids at home, we have a lot of demands on us personally and professionally. But clients, when they have a challenge, they do want to know that you have received their email, their phone call. Even if you can't give an immediate answer, just acknowledge that you have heard from them, and that will go a long way. And they also just don't like to wait. So as soon as you can be responsive, the better. In the end, clients want to be taken care of. And so you want to make sure that you do have a very client-focused approach, that you are being responsive. I encourage you to get their feedback. And I guess that is my time. So good luck to everyone, and enjoy taking care of your clients in this environment.
Thank you, Cynthia. Thank you for this. May I ask, is your background legal? Are you a lawyer yourself?
No, so I'm a marketing professional. So I currently work in administration and marketing and business development, but I tend to bring the voice of the client to my attorneys at my law firm. We have 160 attorneys, and I have found that it's actually better sometimes to have a non-attorney in the conversation, because I can help empathize and bring a perspective to them, because as trained legal professionals, there's a mindset there that might be different from our clients who are not all attorneys. Certainly in-house counsel are, but not all clients are attorneys.
Thank you very much. That's the reason why I was asking. It's clearly a very different type of discourse. So it's very interesting. Thank you for this. Our next speaker is Mr. Martin Malinowski, partner at Upwind Legal, Rechtsanwälte, Wiesel Malinowski. I hope I got that well, in Germany.
That you got that very well. Thank you, Stephanie.
So you will consider... Hello.
Yes,
hello.
Sorry.
I was going to say that you will consider how to attract more clients following Cynthia's good advice. So the floor is yours. Thank you very much, Martin.
Thank you very much, Stephanie. Yes, thank you very much for the quick introduction. As stated, my name is Martin Malinowski. I'm a German lawyer, and I am a partner for Upwind Legal. We are a law firm, boutique law firm, I have to say, specialized in Hamburg, specialized in the yachting and super yachting business, private and business aviation, as well as in the field of super and hypercars, as well as exclusive vintage cars. We are a very new law firm. We only started 9 days ago on 1st of September, and my partner Julia and myself were both partners at INSYS, or INS&Co, whose international senior partner will speak directly after me. And Julia and myself were co-heading the super yacht and private aviation unit at the Hamburg office of the major shipping law firm INS. How to attract new clients is my topic for today, and where I have to disappoint you, you will not receive the master voodoo recipe from me, which you can apply, and every client will directly, or intended client will directly fall in love with you. However, as stated, we are a brand new firm, and that of course made us reconditioning and also reconsidering measures, ways, how we approached things, how we worked, and so on. And even though INS was quite ahead of its time and still is ahead of its time when it comes to modern technology, to great means of attracting clients, we went through a process of what can we adapt, what could we redefine or define even further, and what could we change. So this next couple of minutes might serve as food for thought for you. Obviously, one key aspect in attracting new clients is visibility. In Germany, we have a saying which basically states, do good and speak about it. What that means is, or what that doesn't mean is that you should show off about what you do, but what you can do and should do is share what you experienced, from which also other could participate. Traditional means for that, of course, were articles, publications, and so on. But as we all know, in particular, social media and the respective platforms provided for complete new means of directly giving input, directly receiving feedback, and so on, which then again rises your market visibility, which again might attract new clients. What we also did in the course of setting up our new firm is defining where do we actually want to go, which we basically defined as a smart networking. So what social media taught us is that every person probably is only 3 to 4 links away from yourself. So you know somebody who knows somebody who knows somebody who knows who you want to work for. Therefore, one important step which we did is concentrating on our existing network, and in particular the phase of communicating that we are starting a new law firm made us reflect on actually our network. So what we did is specify who stands or who's the link between us and the client we want to work for. That of course doesn't need to be a specific client, but can be a field of potential clients, of people or companies you would like to work for. Obviously, in our business, these are mainly defined as owners of cars, jets, yachts, whatever. And by identifying your key producers, your key network, that might indeed help to attract new clients. In our case, for example, we're speaking about brokers, project managers, operators, surveyors, insurers, and the like. And I'm pretty certain that also in your field of business, whatever it might be, there will be similar key contacts, similar fields of people that you might actively engage with in order to get closer to potential clients. One thing that we also did, in particular in the process of transferring and reviewing old files, is take a look into your past. Who did you work with in the past? Who came across your field? Maybe in a project that has been long closed and was, well, not worked on for a couple of years. So were there people that you already found inspiring back in the days? Or were there people that you considered back in the day of being quite young, for example, but definitely have a high potential? In the modern times of social media, it's often just a few clicks or search words away to find out what these people are doing today. And it might be worth getting back in contact with them in order to open new fields, open new opportunities, which again might lead to new clients and new businesses. One key aspect in our field, which might not apply to every field, is a specialization. As coming from a major shipping law firm, shipping was the overall field that we worked in, and also the global shipping business was deemed to be our broad specialization. But shipping, for example, obviously has many facets into which we specialized more and more, being then specialization in yachts at first, looking into ownership structures, looking into registration matters, looking into certifications, and so on, and build up a certain expertise that already in your niche even makes you a specialist in certain fields even more. And also coming back again to the digital world we live in today, as a specialist, you can be easily found through search engines, social media, and so on, also by potential clients. One step that we also took is that we took a look in our neighbor sectors. So from shipping, we went to yachting, always 1.5 decades ago, and identified what are familiar neighbor sectors. In our case, for example, familiar to yachting is private aviation, and having these two fields, you dealing with the clients that often also are the ones you deal with in the third sector, being cars. Also, the topics are often the same: ownership structures, registrations. So if you apply this mindset to your own business, it might be worth looking into neighboring sector. What can the expertise that I have, on which sectors can I also apply that, because they follow basically the same rules than my specialized sector. One thing that might also be worth considering is don't only think in sectors, but think in products that you offer. What do I mean with that? Am I a specialist in litigation? Obviously, as a litigator, you can work in nearly every field. But what is my core strengths? Am I a brilliant contract lawyer? Am I a brilliant negotiator? Am I a well-deserved trustee? Am I a great mitigator? Should I really only offer these services to the field or the sector that I'm currently in? Or can't I reapply that to other sectors as well? In particular, when it comes to smart contracting, mitigation, negotiating, and so on. One aspect that was thrown up by the description of my today's topic is also time efficiency and clients that want things done in less time. As stated, as a new law firm, we also overthought our general concept and our setup. Already at INS, but also now, we thought that it's useful to use client workspaces, workspaces where you can load up files, you can load up correspondence and the like, where you and the client have direct access to, and you can simultaneously work on files, for example. What we try to avoid is sending back and forth versions, having a telcon about it. No, I want you to revise my draft. You revise the draft, you send it back. No, I have still some changes, and so on, which is very time consuming. So often, if you have a client who's very keen in modern technology, in working with modern technology, this is actually a tool that is very time efficient. Working simultaneously on one and the same document, you can directly see what the client is applying. You can rephrase it to more legal terms, for example, and get to result quite quickly. One which might appear being stating the obvious, but I don't think it's like overall general state of the art is cloud-based working. When you consider your day, you probably have a lot of free time, a lot of spare time, being commuting, and so on, which can be better used. We introduce a file which is system which is completely cloud-based filing system, so that we have access to our files wherever we go and are. One last aspect I would take a look on is pricing. Obviously, what you don't want to do is price dumping, but one system that might or is requested more often is what we know in shipping from salvage, which means no cure, no pay. It's obviously a sensitive topic, but might be highly attractive for clients, might be highly attractive for you. First question is it possible in my jurisdiction? In Germany, it's difficult, but it might be something that might be offerable, in particular if you're certain that a certain result will stand up at the end of a project. That's actually just a little bit food for thought that I wanted to share with you. Obviously, it's not the main or the core recipe of how to attract new clients, but it's, I hope, some aspects that might be reconsiderable and might be food for thought for one or the other.
Thank you very much, Martin. That was very complimentary to the previous presentation. So thank you for sharing with us your personal experience. I'm sure we can come back to some of the key points in the Q&A session. The next speaker is, you mentioned him already, Julian Clark, Global Senior Partner at Inns & Co in the UK, who will be talking about virtual entrepreneurship, the need to digitalize the legal sector, and how law firms are changing following COVID-19. I would like to ask Julian to stay within the 10 minutes limit. And again, the Q&A will follow, where we will be able to ask questions. So Julian, the floor is yours.
Thank you very much. Good afternoon, ladies and gentlemen. It's a pleasure to be presenting. I'm not with you on the island, but it's very nice to be with everybody. I'd also like to say to Martin, congratulations on the launch of the new firm. I hope it all goes very, very well, and good luck with that. And hopefully we'll catch up soon when we can travel again. It's a fascinating topic that you've given me to speak on today. And in fact, it's a topic that I'll try and cover in 10 minutes, but one could probably spend an entire conference looking at these issues. So digitalization of the legal system and how law firms have changed as a result of COVID. Well, my own belief is that law was on the cusp of a significant change globally anyway before COVID, due to the fact that coming into our industry like an unstoppable tide are the effects of digitalization, machine learning, and artificial intelligence. And I do think that these will totally transform the way all of us do law, whether that's in a small practice or in a global practice, such as the one that I'm proud to be senior partner of. And I think what we've seen through COVID is an acceleration of that process, because we've had to get to grips with some of the technology and bring some of the technology into bear a lot quicker than any of us anticipated, and against some serious reluctance from areas of our industry, such as the courts and the arbitrators. I remember about a year ago speaking to the London Maritime Arbitrators Association and suggesting to them that in order to keep in front of developments in technology, we should be looking at ways to introduce hearings by way of blockchain, process of disputes by blockchain, and virtual hearings, because this was something that was being done already in Dubai, and it was already being done in China, where they have courts of blockchain and virtual hearings. This was before COVID. And the response I got from the LMAA was not at all positive. In fact, it was very much, that would never work, and we can't see why we want to accelerate or introduce this. And of course, if I'd had a crystal ball, I'd have been able to show them that with only a few months later on, we all have embraced this. So in the time I have remaining, let me cover some general points for you. how we at INS have adopted our way of working by embracing agile working, the impacts that this is having on training of our junior lawyers, the issues that it's raised in relation to compliance and cyber risk, and finally, a little bit about the technology and what is available now to law firms. As Martin said, is very much at the global end of the sphere of law firms. We are 120 partners. We are over 500 fee earners operating from 14 offices worldwide. And in the UK, believe it or not, we operate out of 8 buildings now. So we have 8 buildings through our regional network with 3 separate offices in London, one in Mayfair, well, sorry, 4 in fact, one in Mayfair, one in Wandsworth in southwest London, the main office at the Aldgate Tower in the city, and then another office in Lloyd's building. And since the pandemic, the entire operation in the UK has run virtually. We do now have access to our office in Mayfair, but our Lloyd's office and our main office are totally closed. And that's where the majority of our UK-based staff operate. There has been, and I've just lost my screen. I don't know if you're still there. Hello?
Yes, we can hear you. We can hear you, Julian.
That's great. I just lost my camera, but I shall keep going. Thank you.
We can see you as well. Well, no, I think the image has actually frozen. Okay. But we can hear you.
As long as you can hear me, I'll keep talking to you.
Yes, we can.
You don't get rid of me that easily. So, yeah, so our international network, some of those offices have been back, depending on what's happening in the particular jurisdiction. Others have been working remotely from home. I'm delighted to say that we managed to move on to an agile working, virtual working system, which generally works, I'm sorry I've lost my camera, by using a combination of Zoom and Teams calls. And indeed, I, having taken up my role as the new senior partner, managed to meet all of our 500 fee earners remotely across the network in groups of 4 and 5 at a time. And so that part of the business has worked very well. One thing that we are concerned over, and I think presents some major
I think that now we have actually lost Julian. So let's give it a couple of seconds to see if he can come back. Otherwise, we'll go to the next speaker and come back, yeah? Just a couple of seconds, just to see if he reappears. All right, so I hope that our next speaker is ready. I think I can see her on the screen. We are very honored to welcome Judge Michelle Brewer from the First Tier Tribunal Immigration and Asylum Chamber, Courts and Tribunals Judiciary of the UK. So very warm welcome, madam. You will talk to us about the interplay of human rights and business with a particular emphasis on transparency of supply chains and human rights due diligence. Please, madam, 10 minutes. Thank you very much.
Thank you very much. Ladies and gentlemen, esteemed colleagues, speakers and participants, it's a pleasure and a privilege to participate in this conference. As already explained by the chairwoman, in my presentation today, I'll consider the interplay and interconnection of business operations and human rights. Understandably, the impact of COVID-19 has been the focus of this conference and the impact of this global pandemic on the business community and the legal community that serves that community. So I want to introduce into this mix human rights. Now, like Julian, it's actually a subject area that could take all day, but I've got 10 minutes, so it's going to be a whistle-stop tour. In this presentation, I'll consider 2 matters. First, the role of human rights in the operation of businesses, and secondly, the impact and consequences of COVID-19 vis-a-vis human rights violations relevant to business operations. But I'll first explain why this is an area of interest to me. One of my last cases in practice as a human rights barrister in the UK before my judicial appointment in February concerned a complaint made to the UN Special Rapporteur on trafficking in persons. The complaint is ongoing, but will identify various international businesses and investors whose operations are implicated in significant violations of human rights, including human trafficking, forced and worse forms of child labour. This complaint will likely form part of a publicly available communications report to the UN Human Rights Council, and the various international businesses and investors will be named in that report. So let's look at the role of human rights in the operation of business. Globally, we have a long way to go to make sure that business operations consistently and consciously operate in a manner which is consistent and respectful of human rights. In recent years, there has been global coverage where businesses have failed to take human rights seriously when engaging in business operations. To give an example, we saw the collapse of the Rana Plaza complex in Bangladesh in April 2013, which claimed over 1,100 lives. This tragedy brought renewed attention to the need for businesses to take responsibility for their global supply chains. Another example is the use of forced labor and fishing vessels within the supply chains of global food brands. The global business community itself has, in recent years, provided business rationales for respecting human rights during the business operations. There's good reason for this. The globalized nature of the economy, alongside advances in technology, mean that businesses implicated in human rights violations face significant risks of being held accountable by consumers, investors, employees, communities, business partners, governments, and NGOs. In 2011, the UN Human Rights Council endorsed the UN Guiding Principles on Business and Human Rights, the UNGPs. And for any lawyers, I would say anyone in the legal community that advising business, you should be completely au fait with these principles. By creating these principles and doing so, they began dispelling the narrative that human rights is solely a concern for governments and is not a concern for businesses. The UNGPs make clear that for businesses, the responsibility to respect human rights means seeking to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products, or services by the business relationships, even if they have not contributed to those impacts. There has been an evolution of the way that businesses look at human rights risks. And that evolution needs to also take place in the legal community to be able to deal with that. It is now increasingly seen as a matter of risk management and good governance. Companies have long engaged with the concept of due diligence through investigative processes that aim to identify financial risks associated with business transactions. Human rights due diligence is essentially an extension and continuation of those established risk management processes, but where it takes the lens of the risk to people, recognizing that where there are the most severe risk of human rights, there are material risks to business, including reputational harm, financial loss, and legal liabilities. There is evidence that positive performance on human rights and proactive management of risks to people by businesses can attract investment and procurement opportunities for both companies and governments. Current international authoritative standards, such as the UGPs and the OECD guidelines for multinational enterprises, outline expectations that investors, for instance, as business enterprises, will embed respect for human rights into their core business, their investment activities. It has also led to higher levels of worker productivity and increase in profits. A company can avoid costly and disruptive risks. And as far as the legal community are concerned, it mitigates against legal and financial risk from employee-based litigation. In respect of the last rationale, a good example of share prices reacting to the threat of liability was the seminal tort case in the UK of Lubin Cape plc. After judgment was handed down by the House of Lords in 2000, Cape's share prices plummeted sharply on the London Stock Exchange. So what do I mean by human rights due diligence assessment? The UNGPs, the authoritative global framework on business and human rights, defines human rights due diligence as an assessment of the actual and potential human rights risks and impacts of business operations, including supply chains. It must be directed at substantive, transparent goals and not simply form a superficial human rights compliance or one-off exercise. Human rights due diligence therefore needs to be transparent, ongoing, and frequent. It's a process that must identify, prevent, mitigate, and account for any potential or actual human rights risks involved in business operations, including down the supply chains. And how do they achieve this? Well, they have to assess the actual and potential human rights impacts that may be caused by a business or to which it may contribute or be directly linked through its business relationships. Interacting and acting on those findings, tracking the effectiveness of those actions, publicly communicating the company's human rights policies, practices, actions, and outcomes, addressing identified risks and or impacts. Development and embedding of human rights policies across business, enable remedy where impacts occur, and engagement when potentially affected groups and stakeholders when developing policies, procedures, and organizational processes. And incredibly importantly, currently, companies should consider the impact of their policies and processes on the public health of each community in which they operate or invest to minimize the risk of spreading disease. So just to conclude, let's think about the impact and consequences of COVID-19 for the global workforce now. There are 40.3 million people estimated today to be in modern slavery. The International Labour Organization reports that the economic and labour crisis created by COVID-19 may see global unemployment increase by almost 25 million. There is a prediction that there will be between 20.1 million and 25 million more people in working poverty because of COVID-19. Why is that relevant to your clients? Well, individuals will be more vulnerable in this context and will be at heightened risk of labour exploitation. COVID-19 is expected to heighten the risks of people who are already in exploited situations, increase the risk of exploitation, including child exploitation, and will also have an impact on disrupting response efforts to labour exploitation. On the 8th of June 2020, the UN Special Rapporteur on Trafficking released a position paper on the impact and consequences of COVID-19, the pandemic, on trafficked and exploited persons. She observed that the current crisis caused by COVID is bringing to surface existing inequalities and vulnerabilities. One of the central concerns for the Special Rapporteur is the disruption of supply chains. Shortages of labour is disrupting the production, processing and distribution of food. It is estimated in Europe that there's a shortfall of over 1 million seasonal agricultural workers that are usually drawn from Eastern Europe and Northern Africa. The outbreak is also disrupting the manufacturing businesses around the world. Garment workers are losing jobs without safety nets. Migrant workers are not receiving their wages, or they're in debt to the recruiters. All of this makes for a climate in which egregious human rights abuses, including human trafficking and labour exploitation, will flourish. Set this against the potential reduction in import restrictions in critical supply chains, such as medical equipment, for example, will place workers at heightened risk of exploitation. So, for example, in the US, Customs and Borders Protection have just revoked a hold on the import of rubber gloves from a supplier suspected of using forced labor. It is foreseeable that the crisis may cause some countries reliant on large migrant labour forces to either curtail their reliance or place additional restrictions on migrant workers and limit their freedom of movement. It is foreseeable that with schools shutting down, that we will see an increase in child labour. In addition to this, the global pandemic caused by the coronavirus has changed the way we live and work in a matter of months. The spread of the coronavirus has meant no more public gatherings, or very few, a decreased access to public participation and to the courts. So when we set this against this backdrop, it is therefore essential that the principles set down in the UN GPs is embedded and adhered to by your clients. corporations remain in a powerful position to emphasize that the role of civil society is as important as ever. Dedication of resources to identifying increased reprisal-related risks across their operations and along their supply chains, and take action to prevent and mitigate any human rights risks identified is therefore absolutely imperative at this time. And I'll conclude by saying this. I would urge that those of you that are instructed and advising and working with businesses where this will impact, you need to engage with the narrative human rights language and understand what it means if your clients are potentially involved or could be at risk of being involved in human rights violations. Thank you very much.
Thank you very much, Judge, for this insight into human rights narrative for law firms. That was very interesting. I'm sure that will trigger some questions. Will you take questions on the topic, I suppose, at the end?
Yes, I'm happy to.
Okay, very good. Now, Julian is back. And if he can hear us and talk to us, then we are happy to listen to the second half of his presentation.
Whereabouts did I get to before you lost me?
Where did you vanish? At which point did you vanish? Well, you were describing your firm, and you were describing the fact that some of the offices were closed. You explained that, keeping in touch with the fee owners wasn't an issue. And then I think you were going to talk about clients, probably.
Thank you.
No, cybersecurity. You also mentioned cybersecurity as one of the last points.
Thank you. Yeah. So thank you for that. So yes, I think we talked about agile working and how that was working quite well, and that we were keeping in communication with our teams and our clients. That training was an issue and a concern. That how do we look after and train our new lawyers who find the experience of just being in the environment of a law firm so vital. So that's a concern going forward. And then I think I've moved on to say, in relation to compliance and cybersecurity, obviously we're all very geared up wherever we are in the world and under whichever legal regulation we operate to ensure that we comply with the regulations of that regulator. And more so that we ensure that our systems are cyber secure. We have seen an alarming increase in cybercrime targeting law firms, and indeed we've even seen incidences in the US of opponents hiring hackers to break into rival law firm systems in order to read confidential information, privileged information. So cybersecurity is a big deal now for law firms. One of the issues that we're facing post-COVID and this more agile way of working is the fact that our systems, while geared up for the office, are not geared up for working at home. And although many law firms, such as ourselves, will supply our lawyers and our support staff with laptops, Surface Pros, that are owned by the firm, that have the firm's firewalls embedded in them, that are strictly not to be used for social media or Facebook or anything like that, so they're kept as secure as possible. It's one thing enforcing those systems and complying with those systems when everybody's in the office and occasionally working from home. It's a whole different issue when people are regularly working remotely. And I think that's something that's going to be a cost exposure for firms going forward, as will be the costs of ensuring that people have a safe working environment at home. We have been very concerned over the mental health pressures on our people, especially where those people are working either isolated, they may be living on their own, they may only be in a flat, not have somewhere where they can easily work, or equally as stressful, perhaps they're a parent that have a young family and the young family's been at home as well. And then another security concern, a number of young lawyers, certainly in this jurisdiction, in their early years, will share accommodation together, so that often you may have lawyers from different firms in a flat share, And that obviously raises issues with regard to confidentiality of papers and what's clients' confidential information. So finally, on this topic, I said I'd say a little bit about the types of technology that we're seeing coming into our sphere. And I do believe we'll see this more and more. I do believe it's a tidal wave that we cannot hold back. In relation to processes such as discovery, the creation of documents, the creation of contracts, we're seeing a rising use of machine learning and artificial intelligence. In relation to hearings, I think I mentioned before I was cut off the fact that when I'd approached the LMAA and suggested we look at blockchain solutions and remote ways of conducting hearings, that wasn't accepted enthusiastically. Yet here we are conducting arbitrations and court hearings every day. I've been involved already in a 3-week salvage arbitration. That was one of the largest salvage arbitrations that London's conducted, which was all done remotely. Currently involved in another ICC arbitration, which is cross-border and involves 6 different countries with arbitrators from 3 countries. And that arbitration would have taken place live in Paris, but will now be conducted completely virtually. So the examination, cross-examination of witnesses, the preparation of bundles, the presentation of experts' reports and cross-examination of experts will all be done in a virtual forum. And I do wonder how, over time, we will stand up to that in an adversarial process where so much can turn on the pressures of facing a skilled litigator or counsel in an actual hearing, and whether that will fully transpose into a virtual environment. We've also seen changes in our own firm in relation to shipping by the use of technology for casualty investigation. So we are now using drone technology and other technologies in order not only to monitor ships and monitor ship collisions, but also to collect physical evidence from ships remotely without having to send mariners out to attend casualties. Now, none of this, I believe, is ideal, although it is something that we need to embrace because I think we can't stop the technology and the impact it will have on our industry. And I think the other reason why we can't avoid this is because we've seen that the Big Four have all now realized that they can extend their consultancy services into the field of law, something where they tried once before, not successfully, but this time are trying with what appears to be far more commitment and aggression. And of course, the benefit that the Big Four have over traditional law firms is that they have the backing and the finance to truly embrace technology and bring this online. And I think that is going to be a major factor for law firms going forward. I believe that if I add together the time I've just spent with you now and the time I had before I was cut off, that's probably my 10 minutes. So thank you very much. And I am around for questions.
Thank you very much, Julian. Indeed, you did your maths right. That was correct. So thank you very much for this. We now have, however, a session for Q&A. So hopefully our speakers will have a few more seconds to add a few sentences. So I'm inviting the delegates to participate in the discussion. I have a couple of questions here submitted already by some of the delegates, and if the speakers don't mind, I will start with our judge, with Judge Brewer. Judge, is there a code of conduct or obligations or a guidance from professional bodies in the UK regarding the points raised in your presentation? So I suppose the delegate is referring to human rights due diligence, and he or she is thanking you for the interesting presentation.
I have always worked when I've done litigation, and I have to say my litigation practice as a barrister was as a human rights barrister, I wasn't a business litigator. And we always looked to the UN principles. So that was where we drew on. Businesses themselves, that maybe that Julian or Martin would be able to assist, whether they're aware of any domestic guidance that has been drawn up. The only domestic guidance that I can think of perhaps is what came from the Modern Slavery Act and the obligations under Section 54, which was to produce a statement if you had a turnover of 36 million pounds. But that is the only one from my practice when I was litigating that I would recall. On my own litigation, we usually drew from international and regional instruments and guidance. And from my perspective, I think one of the best documents that any lawyer can look at to begin informing themselves is the UN Guiding Principles on Business and Human Rights. And another interesting inquiry to look at is the Joint Committee on Human Rights in 2016 looked at human rights in business in one of their inquiries and put together a very detailed report. And again, that will give very good guidance and insight into the interplay between human rights and business. I hope that helps.
Thank you, Judge. If I can just have a follow-up question on the same item. While you were speaking, I was thinking in my head that the way due diligence has penetrated or the way risk assessment has penetrated law firms in terms of privacy because of GDPR or in terms of anti-money laundering. Can't you imagine in the future a similar process put in place internally within law firms for themselves and their clients that would involve a dedicated group of staff, both internal and external, to actually deal with human rights due diligence?
I think actually it would have to be well, I say have to be. I think to be most effective, so to be something that is sustainable human rights due diligence assessment rather than something that is a one-off cursory assessment, you will need to have embedded in your with your lawyers those that specialize in international human rights law and understand the domestic legislation around human rights. So for us, we work with the European Convention on Human Rights and then the Human Rights Act, and then we look also to the international umbrella. You would need, I think, coming from a human rights background, I think it's something very difficult to dip in and out of. I think it needs to be very much your specialism and your expertise.
Thank you very much, Judge. Would Julian or Martin have something to add to the point raised by the judge, which is if you can help our delegates to perhaps make their way through guidance, to reach guidance on human rights due diligence? I'm thinking on top of my head that the Law Society probably has information on its website.
For example, yes. Oh, sorry.
Oh, Martin.
Julian, you go first, please.
Thank you, Martin. Certainly the SRA, the regulatory authority here, has a number of rules which would regulate your conduct as a solicitor, which would bring you into human rights legislation as a professional. Certainly more and more in all of our firms, we're seeing the importance of diversity and inclusion, and that's something that's important not only for the people that we're recruiting, but also for our clients. And certainly in relation to a number of major pitches now, clients will ask not just for your legal criteria, but also what you do for a whole list of things, including what is your stance on human rights, what is your stance on the environment. So I can see it becoming much more of our due diligence process going forward. And indeed, one area that's very close to my heart in relation to shipping, and something that I know the IMO have been approached about, is slavery in the international shipping field and what the community is doing in relation to that. So I do think we'll see more of this going forward. Martin?
Yes, similar in Germany. I mean, if you take a look at the rules of the German Bar Association, you have kind of often catch-all phrases demanding lawyers to respectful conduct towards the clients, towards their opponents, towards their colleagues, and generally sets high standards of a lawyer conduct. And as it is a catch-all phrase, it also follows from legislation, from rulings from the respective courts to further define that. So I think there are also through many court decisions what is a misconduct, what is not a misconduct, where to draw the line. We are kind of in a floating process in further defining a code of conduct and respective compliance regulations.
Thank you very much, both. There is one more question, which is primarily addressed to Julian, but I think that Cynthia actually could give us the US perspective as well. So the question goes, I'm grateful to all the speakers, but my question is primarily directed towards Mr. Julian Clark. In the epoch of the pandemic, when verbal communications with clients have to be conducted electronically, can true client confidentiality be guaranteed? I ask that question mindful of the various risks associated with electronic communications, such as hacking. So how does a law firm in the UK or law firm in the US deal with clients' communication confidentiality?
It's a major concern. I think it was a concern that was prevalent even before COVID, because we were seeing more and more clients' communications on by WhatsApp, by text message, by WeChat, especially if you're operating with clients in China. And you do become very worried about that confidential information being passed backwards and forwards. And while, as a law firm, a great deal of our expenditure is based on our cybersecurity systems, we of course can't know what kind of cybersecurity systems our clients have. So I do see it as an increasing issue going forwards, and something that we'll have to address.
Thank you very much, Julian. Cynthia, the final words are yours because we have to move on. Thank you.
Yeah, I mean, certainly I think with people working remotely from home, so it's not just electronic communication, but working from homes where they might be sharing with other professionals. And Julian talked about this a little bit with the younger attorneys, you know, making sure that you're using secure connections like a VPN connection, that you're not on open networks, that your cybersecurity protocols are all in place. I mean, it is an ongoing challenge, but I do think firms here in the United States have been working very hard on it. And even just some tactile things like we've sent shredders to all of our professionals, both staff and attorneys alike, so that if they have any printed communications, they're using a secure P5 micro crosscut shredder, so that any information that's outside of the walls of the firm can be securely disposed of. But more to come on that as we deal with potential breaches that I'm sure will result, unfortunately, as a result of more electronic remote work.
Thank you very much, Cynthia. So I'd like to thank all four of you for having accepted our invitation and having given us your views and contributions, valuable contributions. And I would like to invite you to stay with us for the rest of the proceedings, if you can. We now have the honor and the pleasure to welcome Mr. George Savvidis, the Attorney General of the Republic of Cyprus. As the Attorney General could not be with us live, he has kindly recorded his intervention, presenting the law office of the Republic in the digital world.
Ladies and gentlemen, I'm honored by the invitation to address today's conference and such a distinguished audience. I would like to thank IMH for the kind invitation and to express my gratitude to all participants this afternoon. Allow me to start by saying a couple of words about the ambitious plan to reform the judicial system of Cyprus. The rationale behind the proposed changes is to speed up the administration of justice by building a modern, quick, accessible and efficient system based on some of the best practices in the world, so as to bring the time required for complete determination of civil cases within the limits of other EU countries. Having been personally involved in the process under my previous capacity, and also strongly interested under my present capacity, I sincerely hope that all stakeholders will share the vision of a holistic courts reform, and that the legislature will proceed with the enactment of the draft bills, so that we shall soon see their implementation and the creation of a modern system of which we shall all feel proud of. It goes without saying that the introduction of e-justice, which is an integral part of the designed reform, is a key element in the modernization of our judicial system and an absolute necessity in a world that is becoming increasingly digital. As remote working gains ground in the post-COVID-19 era, the legal sector will undeniably be driven into a total digital transformation in order to meet and cope with emerging challenges and the needs of the legal industry. With the above in mind, I shall now move to the main topic of my presentation today, which is the project to reform the Law Office of the Republic of Cyprus, an office that I have the honor and privilege to be heading. Let me say right at the outset that upon taking office, I was truly impressed with the level of the legal skills, commitment, and determination of my colleagues in the Law Office of the Republic. I consider myself fortunate that the Deputy Attorney General is a person I respect immensely, both as regards his legal expertise, but also as regards his character. The two of us have a common vision to improve the law office and invest in digital infrastructure, with the final aim being the improvement of quality, but most importantly, the response time for the accomplishment of the various tasks that we have to deal with. Digital transformation is vital for the Law Office of the Republic, which is very much lacking technological tools. As paper folders and binders don't do the trick anymore, innovation is a one-way direction for us. Our aim, therefore, is to focus on wider opportunities so as to make a positive impact on our performance. We aim for greater productivity and efficiency, better organization, and more effective communication with media representatives and the public. In order to do so, a number of changes have been immediately introduced upon assuming our duties, in order not only to upskill and adopt new ways of in-house working, but also to monitor the progress of our work, introduce better coordination structures, and solve problems through practical and immediate solutions, making thus our work easier. An immediate change was the creation of the private office of the Attorney General, presently staffed with a director and a press officer. The mission of the office is to achieve better coordination and monitoring of the work of the Attorney General and the Deputy Attorney General, assisting in the smooth functioning of both officers. In a world where social media are changing the nature of communication and news, especially fake news, is spread in the blink of an eye, establishing an effective communication with the public and media is of the essence for disseminating direct and credible information and for promoting transparency, authenticity, and trust. Two of the most important communication platforms are the Law Office website, which is currently being upgraded, and on social media, the Law Office Twitter account, which has been set up for the first time. Furthermore, we're in close contact with the Deputy Ministry of Research, Innovation and Digital Policy for the introduction of the latest technology available for the internal recording and monitoring of various pending cases and for updating internal information for the members of the law office. Through a proper reorganization, which is very much in progress, our aim is to timely conclude pending cases and to maximize the efficiency, productivity, and speed of the law office in dealing with the great volume of work that is currently dealing with. I wish to express my special thanks to Deputy Minister Kyriakos Kokkinos for his commitment and help towards this end. By investing into our future possibilities that spring from digital transformation, we invest in our people. The law office, as I already said, has bright minds, hard-working professionals with high quality of legal knowledge and expertise. We have a duty to give them the technological tools that will enable them to quickly find the information they need, to quickly research into material which already exists, to share and pursue knowledge, and to become operational faster. This means changing the way we conduct the daily business. Instead of the manual processing of the massive paperwork, cloud technology and other digitally based solutions will be adopted for the internal conduct of digital research into legal documents and materials, such as important legal opinions issued by former attorneys general or other members of the law office, and other important documents will be digitized for easier storage, retrieval, and use in the future. Ladies and gentlemen, COVID-19 has become a catalyst for even more rapid digital transformation, which has been identified as a cornerstone of economic recovery. As technology dramatically reshapes every single industry, legal profession has its own share. A change of this sort is likely to require a substantial cost in terms of infrastructure and labor cost. Yet, in the long run, the investment cost can be transformed into long-term cost saving. In the case of the Law Office of the Republic, digital transformation is a means towards our core priority to increase our productivity and efficiency, adjust and address contemporary challenges so as to best accomplish the various tasks entrusted to the Law Office. Thank you.
We thank the Attorney General for his recorded intervention. And we also have the honor and the pleasure to welcome Justice Stelios Nathanail, President of the Supreme Court of the Republic of Cyprus. As the President could not be with us live, he has kindly recorded his intervention, presenting his predictions for the future of the judicial system of Cyprus and its reform.
Good afternoon to all. My intervention relates to my predictions about the future of our justice system. We all appreciate that any justice system is a highly complex organism, a pulsating living entity. We generally talk about the system of justice when we actually refer to the court system itself. This, however, is not accurate. The justice system encompasses many other actors, like the police, the Attorney General, and the lawyers. Judging is not done in abstract. Therefore, when we talk about delays, this is a result of a multitude of factors with the involvement of many actors. This conference focuses primarily on civil justice, so I need not say anything about criminal justice. Parties in civil cases act on the advice of lawyers, responsible for presenting the case in court in a coherent, legal and practical manner. If this is done properly, it can really help in speeding up justice. Judges, on the other hand, are responsible for the orderly and speedy conduct of the proceedings and of reaching a conclusion on the merits in an unbiased, independent and legally correct manner as soon as possible. Even if all the above are in a manner that is helpful in delivering speedy justice, one still needs the resources that have to be provided by the state. One needs enough judges, registrars, other manpower like registrars, stenographers, court assistants, and of course sufficient, adequate and respectable court buildings. Technology is not merely a necessity, but the sine qua non of any decent justice system. If any of the aforementioned is missing, this is a factor for failure. It must be admitted that we have not done well over the years in securing this efficiency. The courts have been slow to react to the so many changes that came about on account of our joining the European Union, while the economic crisis that followed put an enormous additional stress on the court system. One should never forget also the immense problems that were and are still faced as a result of the illegal Turkish invasion and the unlawful partition of the island. Governments over the years, as well as lawyers, have not done enough to ameliorate the situation. The current state of affairs, however, is much better, and so I am optimistic. Why? Because the whole system is currently under immense reform. On account of the delays faced, a feature of many a modern justice system, the Supreme Court, with its Office of Reform and Training, having recognized the problem, a key feature for any real change, has paved the way forward for a number of fundamental changes. Having therefore identified the key problem, through successive reports, finally and actively, the Supreme Court sought the support of the European Union. The functional review of the court system of Cyprus of March 2018 formed the basis of a number of changes. Establishing again a Supreme Constitutional Court and a High Court in the manner that these two courts function under the Constitution of 1960, with checks and balances over each other so that all functions and powers no longer rest within the same judicial body. An appeal body of 16 judges will be eventually established, and a lot of the current workload of the Supreme Court will eventually be transferred to it. All appointments will be done under criteria to be established by a Judicial Council, in which the Attorney General, the President of the Bar Council, and one lawyer of long standing will participate, securing the selection of the best candidates, which will include, of course, any lawyer wishing to apply. The government has been very keen in combating delays and has been actively supporting the way forward. We already have a lot of stenotypists that have made possible the immediate availability of the trial records, with the option to purchase the system, while at the same time, one of the projects of the European Union is the use in all courts of an audio recording system that I believe will be a very useful addition. Technology is finally on the way. As fully justice is still 2 to 3 years away, an intermediate mini e-justice will be installed by the end of October this year, with the invaluable support and help of the Deputy Ministry of Research, Innovation and Digital Policy, which will literally transform the court filing system and will make life for all stakeholders so much easier. A completely new set of civil procedure rules is underway, while two new courts, the Administrative Court and the Court of International Protection, have already been set in place, have taken off the current Supreme Court a lot of its workload, while at the same time providing expertise in specialized areas of the law. A commercial court and an admiralty court are envisaged to be established in the near future. A task force is in place to tackle backlog cases in district courts. A good number of new district court judges were appointed recently, following the new strict and transparent criteria set up by the Supreme Council on the recommendation of a report of European experts. Likewise, promotions are done based on a new selection process and criteria. A new transparent and detailed code of ethics has been approved, while new stricter guidelines are in place on the recusal of judges when trying cases. All of the above have been the result of the initiative of the Supreme Court, with the assistance of the state and of the European Union. At all levels of deliberation, the Bar Council and the local bar councils were involved, and it is regrettable that the Law Committee of the House of Representatives has suddenly decided that more deliberations are needed. I sincerely hope that the reformation of the courts will soon become a reality, so that all involved can start on a new and hopeful note, with a simultaneous change in our mentality and with court discipline. Thank you very much.
We thank the President for his recorded intervention. And we finally have the honor and the pleasure to welcome Ms. Emily Giolitis, Minister of Justice and Public Order of the Republic of Cyprus. Hello, Madam. Who will present her predictions for the future of the judicial system of Cyprus and its reforms. Madam, the floor is yours. Thank you.
Good afternoon, everyone. I'm very happy to be speaking today to a distinguished audience on a matter very close to my heart, that of the judicial reform in Cyprus. Everyone, of course, has an opinion on how a justice system should operate and how judicial reforms should be implemented, and I, of course, have my own. So although the return of the much debated reform bills to the ministry to which I was very freshly appointed was a perceived setback, it does have a silver lining in that it gives me the opportunity to participate in a process which I would very much like to have a say on. A well-functioning system of justice is a fundamental right of citizens enshrined in Article 6 of the European Convention of Human Rights. We Greeks, of course, have a long tradition of philosophizing over what is just and how justice should be meted. And contemporary concepts of justice are mostly rooted in ancient Greek philosophy, which abounds with diatribes over judicial justice, procedural justice, distributive justice. The goddess of justice was Diki, her sisters being Evnomia, good order, and Irini, peace. Importantly, Diki is Zeus's daughter, which hierarchically places her very high on the godometer. She sits next to Zeus on his throne and arranges all human affairs. Diki brings enlightenment by protecting justice and by rewarding virtue, but at the same time she punishes and provides retribution for injustice. This is why, as you will note from the depiction, she's always blindfolded, for justice is blind and impartial, and she holds a two-tray scale in one hand to weigh the evidence presented to her, and a sword on the other to symbolize enforcement. But while Diki protects others' rights, she was unable to defend her own. Philostratus, in the life of Apollonius, muses, I am certain that Diki will appear in a thwarted light, for while she was appointed by Zeus and the Mire, the Fates, to prevent men from being unjust to one another, she was never quite able to defend herself against injustice. And this is precisely where we are at today. For while we have a functioning system of justice uniquely evolved around our own history, we have a rich common law heritage to draw upon, which has served us well over the years in upholding the rule of law and attracting foreign investment, and the somewhat arthritic, if I may, but still functioning public law legacy from the continental tradition, Diki, or justice, is at saturation points. She can no longer defend herself. It is time, and I think everyone on this panel and in your audience agrees, for reform. The court delays and the effective meeting of justice must be remedied through structural and procedural amendments. The role of the EU in pushing for reform has been instrumental through the publication of country markers such as the EU Justice Scoreboard, as well as the provision of country-specific recommendations. But I think that scoreboards aside, everyone involved in the Cyprus justice system independently recognizes the need for urgent change. In our meeting last week on the 2nd of September with the Parliamentary Committee of Legal Affairs, we agreed to set up an ad hoc working committee consisting of one representative of each party participating in the Legal Affairs Committee, as well as the President of the Cyprus Bar Association. I'm very happy to report that the parties to the Legal Affairs Committee have since reverted, each with a chosen representative, and that their written proposals to the draft bills, together with those of the President of the Cyprus Bar Association, I'm expecting during next week before our proposed first meeting on Wednesday the 14th. I have made it clear to all participants that I am available at any time before our first meeting to discuss any concerns and proposals that they may have in person. I would like our first meeting to be as constructive as possible, and I can only achieve this by being proactive prior to the first meeting, in bridging any differences and building a working consensus. I very much hope that by our second meeting before the end of this month, we will together have formed a common understanding and proposal for the amendment of the 3 bills. These laws are going to form the backbone of our justice system for years to come, and this realization brings with it a very heavy responsibility to do it right, to the utmost of our abilities, for the benefit of our citizens, and for the benefit of all those who choose Cyprus as the forum to settle their differences. Because an efficient justice system also underpins economic development. Where a robust judicial system guarantees the enforcement of rights within a reasonable time frame, creditors are more likely to lend, lenders are more likely to secure financing, startups are more likely to invest. If we instill confidence in our justice system, we will create a climate of certainty and foreseeability which will enable businesses and investors to plan ahead. A thriving private sector and the ability to attract foreign direct investment are direct benefits of a robust rule of law and a functioning justice system. I note with satisfaction that the reforms include the creation of a commercial and a shipping court. It is very likely that the vast majority of cases this court will hear will concern not differences between Cyprus nationals, but international cases of investors who have chosen to set up their companies in Cyprus, or to provide security for a loan by pledging Cyprus shares, or to settle shareholder differences arising out of a shareholder agreement concerning their Cyprus investment. Cyprus has achieved recognition through the use of regulatory tax and other competitive advantages as a world-renowned services center. We have not been as proactive, if I may, in advancing our jurisdiction as a forum for investors to settle their differences. We can do this if we deliver an updated, just and efficient justice system building on our common law heritage and traditions. We can do this by allowing for innovation, such as allowing the use of the English language in commercial disputes before the commercial court, where both parties to the proceedings agree to the use of English. It is a suggestion I intend to make, and which I hope will be welcomed by the parties and the stakeholders. We must also look at process. The current justice reform bills, which have been returned to the Ministry for further consultation, mostly concern structural reforms. We must also look at procedural reforms, which will supplement the objective of delivering a faster, more efficient justice system. One suggestion is a limited right of appeal, whereby an applicant will seek leave from the Court of Appeal before lodging the appeal. I have indicatively asked the court registrars to provide me with some numbers on appeals so as to build a case for leave. You will see that the latest completed figures are for 2013 because thereafter the appeals are still pending. In 2013, of 359 appeals filed and 278 heard, only 12% were overturned, and the appeal took an average of 73 months to be heard. Another idea is a small claims procedure whereby for claims of specific categories concerning sums below an agreed threshold, the claims will be filed electronically and decided by a judge within a set time frame. The Dyson Committee review of the Civil Procedure Rules, translation into Greek of which is pending since 2019, does contain a small claims procedure, but in my opinion, the entirety of the rules review is a huge task, which we are overly optimistic to replace in one go. The small claims procedure is not simple enough for a small claims procedure, and e-justice will catch up with us, requiring other amendments. We must not delay further in making those procedural changes we can, piecemeal, which will unclog the system. Small changes such as disallowing multiple adjournments will also help in alleviating the load and reducing delays. I am both honored and humbled to be at the helm of the Ministry of Justice at a time of historic change. My mission is to safeguard and advance a safe, just, and inclusive Cyprus. This must include a reformed, state-of-the-art court system, which can deliver justice effectively without undue delay. I promise to do my best to build the consensus necessary to achieve precisely this. Thank you.
We thank you very much, Madam, for your intervention. No questions will be taken as we move on to the panel discussion on the justice process in Cyprus and the need for substantial reform that will be conducted in Greek by moderator Dina Kleanthous.
Κυρίες και κύριοι, καλό σας απόγευμα. Δίνουμε συνέχεια στη συζήτησή μας γύρω από το θέμα της δικαιοσύνης, η οποία αναμφίβολα χρήζει εξυγχρονισμού και θα έλεγε κανείς πως η μεταρρύθμιση της είναι μονόδρομος. Έχουμε την τιμή να φιλοξενούμε μαζί μας 3 έγκριτους νομικούς, οι οποίοι είναι ανάμεσα στους υποψήφιους που διεκδικούν την θέση του Προέδρου στις πανκύπριες εκλογές του Δικηγορικού Συλλόγου, τον Δόκτωρ Χρήστο Κληρίδη, τον κύριο Κυριάκο Θεδωρίδη και τον κύριο Θανάση Κορφιώτη. Καλό σας απόγευμα.
Καλησπέρα.
Καλό απόγευμα σε όλους.
Καλό σας απόγευμα. Να ξεκινήσουμε τη συζήτησή μας με μια τοποθέτησή σας και να μας αναπτύξετε λίγο τις θέσεις σας και τα ζητήματα που έχετε ως προτεραιότητα στην ατζέντα σας σε περίπτωση εκλογής σας. Να ξεκινήσουμε αλφαβητικά και να δώσουμε πρώτα τον λόγο στον κύριο Κληρίδη.
Καταρχάς να ευχαριστήσω το Πανεπιστήμιο UCLAN αλλά και τους διοργανωτές, την IMH, για την εξαίρετη αυτή διοργάνωση με εξαίρετους ομιλητές στο πλαίσιο του Second Legal Conference. Είχα ακούσει με μεγάλη προσοχή τους προλαλήσαντες και την Υπουργό Δικαιοσύνης. Διαβλέπω ότι υπάρχει μια βιασύνη θα έλεγα, στην θέσπιση των πολύ σοβαρών και θεσμικών τροποποιήσεων. Θα έλεγα ότι εν ώψη του ότι οι δικηγόροι κατεβαίνουν σε εκλογές για τους τοπικούς και συλλόγους αλλά και τον Παγκύπριο Δικηγορικό Σύλλογο, θα ήταν φρόνιμο να αναμένει κανείς την εκλογή της νέας ηγεσίας για τα θέματα τα οποία προκύπτουν και ανακύπτουν από την πολύ σημαντική μεταρρύθμιση. Η πρόκληση, όπως είναι στο πρόγραμμα, αφορά, και σε αυτό θα περιοριστώ, θέματα κρονισμού, όπως επίσης και την ποιότητα των αποφάσεων ή μεροληψίας, για την οποία έχουμε ακούσει σε διάφορα χρονικά διαστήματα κριτική η οποία εκτοξεύεται εναντίον δικαστικών αποφάσεων. Είναι ένα κέριο θέμα και θα έλεγα ότι σχετίζεται πρώτα με τη σύνθεση του Δικαστικού Συμβουλίου στην Κύπρο, το οποίο Δικαστικό Συμβούλιο αυτή τη στιγμή απαρτίζεται από μέλη του Νοτάρου Δικαστηρίου. Η έκθεση της Γκρέγκο όμως έχει προτείνει όπως διευρυνθεί η σύσταση του Νομικού Συμβουλίου και επιπρόσθετα τα μέλη του να εκλέγονται από τους ίδιους τους δικαστές, ακριβώς για να αποφευχθεί ο κρονιτισμός στην διαδικασία διορισμών και προαγωγών των δικαστών. Κατά τη γνώμη μου είναι επάναγκες στο νέο Δικαστικό Συμβούλιο, πέραν των εισηγήσεων συμμετοχής του Γενικού Εισαγγελέα, του Προέδρου του Παγκύπριου Δικηγορικού Συλλόγου, αλλά και έμπειρου δικηγόρου και κάποιων επαρχιακών δικαστών, να συμμετέχουν και δικαστές από τα ειδικά δικαστήρια, όπως επίσης και δικαστές των επαρχιακών δικαστηρίων όλων των επιπέδων. Χρειάζεται μια περαιτέρω διεύρυνση θα έλεγα και γι' αυτό οι προτάσεις αυτή τη στιγμή θα πρέπει να αναθεωρηθούν και να βελτιωθούν. Πέραν όμως τούτου υπάρχει και θέμα το οποίο αφορά την πρακτική η οποία ακολουθείται μέχρι σήμερα για τους διορισμούς δικαστών στις ανώτατες δικαστικές θέσεις. Η πρακτική η οποία ακολουθήθηκε είναι ότι διορίζονται στις θέσεις αυτές δια προαγωγής μόνον από το υφιστάμενο δικαστικό σώμα και έμπειροι δικηγόροι οι οποίοι θα μπορούσαν να διοριστούν στις θέσεις του ανώτερου επαρχιακού, του Προέδρου ή και στο ανώτερο δικαστήριο από τον Πρόεδρο της Δημοκρατίας που είναι ο εντεταλμένος για τους διορισμούς, έχουν παραγωνιστεί πλήρως. Υπάρχει μια λαθασμένη πρακτική η οποία δεν εμπλουτίζει με αυτόν τον τρόπο το δικαστικό σώμα. Πέραν όμως τούτου θα μπορούσε για να ανατραπεί ακριβώς αυτή η λαθασμένη πρακτική να θεσπιστεί είτε δυνάμει πρακτικής είτε δυνάμει νομοθεσίας ότι το 50% τουλάχιστον των δικαστών θα προέρχονται από τους έμπειρους δικηγόρους. Επιπρόσθετα, για να αποφευχθούν οι καταγγελίες για ποιότητα στις αποφάσεις και κρονιτισμών και ημεροληψία, θα πρέπει να υπάρξει συνεχής εκπαίδευση των δικαστών από έναν ανεξάρτητο σώμα, από μια ανεξάρτητη σχολή δικαστών και όχι απλώς από μια σχολή, να το βάλω έτσι, των δικαστών για τους δικαστές. Θα πρέπει να εμπλουτιστεί δηλαδή αυτή η σχολή με ακαδημαϊκούς, με πανεπιστημιακούς κτλ. Αυτά όσον αφορά το θέμα των διορισμών των δικαστών και την προώθηση της ποιότητας των αποφάσεων. Σαν υποψήφιος για τον Προεδρία του Δικηγορικού Συλλόγου θα πρέπει να αναβαθμίσουμε, αυτή είναι η βασική θέση μου, τόσο τους δικηγόρους, την συμμετοχή τους στο γίγνεσθε της δικαιοσύνης, αλλά βεβαίως και να εμπλουτίσουμε το νομικό μας σύστημα με ένα σύγχρονο νομικό σύστημα με τμήματα στα επαρχιακά δικαστήρια, εξειδικευμένα τμήματα που θα απαρτίζονται από εξειδικευμένους δικηγόρους. Χρειάζεται να ενισχύσουμε το πειθαρχικό συμβούλιο των δικηγόρων για να ενισχύσουμε με αυτόν τον τρόπο την εμπιστοσύνη του κοινού εν γέννη στον θεσμό του δικηγόρου σαν λειτουργού της δικαιοσύνης. Αυτά τα λίγα είχα να πω σαν εισαγωγή. Ελπίζω να μην έχω υπερβεί το χρόνο μου κατά πολύ. Και πάλι σας ευχαριστώ που είχατε την υπομονή στα 5 λεπτών αυτό, στην 5 λεπτή αυτή παρέμβαση να πω τα τόσα λίγα για τόσα πολλά όμως θέματα. Ευχαριστώ πολύ.
Σας ευχαριστούμε κύριε Κληρίδη. Να δώσουμε τώρα τον λόγο στον κύριο Θεοδωρίδη για την δική του τοποθέτηση.
Ναι, καταρχήν καλησπέρα. Και εγώ με τη σειρά μου ήθελα να σας ευχαριστήσω για την πρόσκληση να παρευρεθώ στο συνέδριο, το οποίο είναι πραγματικά ενδιαφέρον, και να παραθέσω και εγώ τις θέσεις μου σε σχέση με τα θέματα που αφορούν τη δικαιοσύνη. Τώρα, όσον αφορά τις προτεραιότητες μου για τη θέση του Προέδρου του Παγκυπρίου, καταρχήν για να καθοριστούν οι προτεραιότητες πρέπει να αναγνωρίσουμε τα προβλήματα που αντιμετωπίζουν σήμερα οι συναδέλφοι. Και είναι αρκετά και τα οποία χρήζουν επίλυσης. Ως πρώτο πρόβλημα θεωρώ ότι είναι η μείωση του κύκλου των εργασιών των δικηγόρων και κατ' επέκταση και η μείωση της δικηγορικής ύλης. Δεύτερον θέμα το οποίο προκύπτει ως πρόβλημα είναι οι νέοι δικηγόροι και η ζωή τους στο επάγγελμα και τα προβλήματα τα οποία αντιμετωπίζουν. Σαφέστατα θα συμφωνήσω με τον Χρήστο, τον Κληρίδη, ότι ουσιαστικό πρόβλημα προκύπτει και με την καθυστέρηση εκδίκασης των υποθέσεων, καθώς και την αποτελεσματική εκτέλεση αυτών, που αντιλαμβάνομαι αυτό είναι ένα θέμα που αφορά ουσιαστικά τις μεταρρυθμίσεις που θα συζητήσουμε μεταγενέστερα. Όμως δεν πάβει που να είναι ένα σοβαρό πρόβλημα. Πέραν δε αυτού, πρόβλημα επίσης αντιμετωπίζουμε και ως δικηγόροι με τις κτηριακές εγκαταστάσεις, οι οποίες είναι απαράδεκτες και χρήζουν αναβάθμιση και εξυγχρονισμών, που στο σημείο που είμαστε σήμερα καθίσταται ακόμα πιο σημαντικό, διότι θα βοηθήσει στην υλοποίηση και εφαρμογή της ηλεκτρονικής δικαιοσύνης, που όπως ακούσαμε και πριν από τον Γενικό Εισαγγελέα και την Υπουργό είναι πρώτον πυλών και θα βοηθήσει σαφέστατα στη διεκπαιρέωση ταχύτερα των υποθέσεων. Ακόμα ένα σημαντικό πρόβλημα που αντιμετωπίζουν οι συνάδελφοι και τους ταλαιπωρεί είναι το θέμα της συνταξιοδότησης, που και αυτό είναι στις προτεραιότητες μου και αυτό χρήζει ειδικής μεταχείρισης. Όσον αφορά τελευταίο πρόβλημα που θεωρώ ότι υπάρχει, είναι το θέμα της αξιοπιστίας και του κύρους του επαγγέλματος μας, το οποίο δυστυχώς πλήττεται από εξωγενείς παράγοντες και είμαστε μάρτυρες πρόσφατα με διάφορα θέματα που ταλανίζουν και την κοινωνία γενικότερα. αλλά επίσης και από την καθυστέρηση απονομής της δικαιοσύνης. Τώρα, όσον αφορά την προστασία του επαγγέλματος και της αύξησης του κύκλου των εργασιών, θεωρώ ότι είναι απαραίτητο ως Παγκύπριος Δικηγορικός Σύλλογος να συμμετέχουμε πιο ενεργά στις συνεδριάσεις της Επιτροπής Νομικών της Βουλής, και σήμερα συμμετέχουμε, αλλά θεωρώ ότι θέματα που αφορούν και επηρεάζουν άμεσα το επάγγελμα μας πρέπει να ενημερωνόμαστε έγκαιρα, ούτως ώστε να τοποθετούμαστε σωστά για αυτά τα θέματα. Όσον αφορά τους νέους δικηγόρους, σαφέστατα πρέπει να ληφθούν μέτρα ούτως ώστε και μισθολογικά και ακαδημαϊκά να είναι πιο εύκολη η εισδοχή στο επάγγελμα. Είναι γεγονός ότι αντιμετωπίζουν προβλήματα οι νέοι δικηγόροι, το βλέπουμε και εμείς καθημερινά στα δικαστήρια. Όσον αφορά την καθυστέρηση στις εκδίκαση των υποθέσεων, αυτό είναι ένα από τα θέματα τα οποία είναι ίσως το σοβαρότερο που προκύπτει στις μεταρρυθμίσεις οι οποίες δρομολογούνται και οι οποίες τώρα έχουν επιστραφεί πίσω σε όλα τα εμπλεκόμενα μέρη για διαβούλευση. Θα καταθέσω τις απόψεις μου στο επόμενο ερώτημα. Σοβαρή προτεραιότητα, η οποία γνωρίζω ότι αντιμετωπίζουν οι συνάδελφοι και τους απασχολεί, είναι το θέμα του Ταμείου Συντάξεως. Είναι προτεραιότητα μου να ολοκληρωθεί η μεταρρύθμιση του Ταμείου Συντάξεως. Έχουμε λάβει αναλογιστικές μελέτες από γνωσμένους κύριους αναλογιστές, με τις οποίες θα βοηθηθούμε να εξασφαλίσουμε την βιωσιμότητα του Ταμείου σε βάθος χρόνου. Τελειώνοντας, το θέμα της αξιοπιστίας και του κύρους του επαγγελματούς, είναι σημαντικό να εξυγχρονιστούν οι κανόνες δεοντολογίας. Μπορούμε να υιοθετήσουμε ένα καταστατικό χάρτη των Ευρωπαίων Δικηγόρων, όπου εκεί υπάρχουν οι 10 βασικές αρχές που καθορίζουν το επάγγελμα, καθώς επίσης να διευρυνθεί το Πειθαρχικό Συμβούλιο, να απλοποιηθούν οι διαδικασίες, ούτως ώστε να εκδικάζονται υποθέσεις το συντομότερο δυνατό. Αυτά εν ολίγης είναι οι προτεραιότητες. Όπως έχω πει, βασίζονται κυρίως στα προβλήματα των συναδέλφων, στο βαθμό που μπορούν να αντιμετωπιστούν από τον Παγκύπριο Δικηγορικό Σύλλογο, ο οποίος είναι και ο εκφραστής των θέσεων των συναδέλφων, με πρώτιστον σκοπό την προστασία και πρόθεση των συμφερόντων όλων των δικηγόρων. Είτε αυτοί εργάζονται σε δικηγορικές εταιρείες, είτε μόνοι τους. Όταν τα αιτήματα τους υποβάλλονται σωστά και τεκμηριωμένα στα κέντρα λήψης αποφάσεων, θεωρώ ότι με σωστή συζήτηση, υποβολή τεκμηριωμένων προτάσεων, θα έχουμε και τα επιθυμητά αποτελέσματα προς όφελος των συναδέλφων. Ευχαριστώ.
Κύριε Θεοδωρίδη, σας ευχαριστούμε. Να δώσουμε τώρα σκητάλη στον κύριο Κορφιώτη.
Καλησπέρα σε όλους και ευχαριστώ για την ευκαιρία που μας δίνετε να αναπτύξουμε αυτά τα ζητήματα τα οποία είναι φλέγοντα τις μέρες μας εν ώψη και των εκλογών που θα υπάρξει στον Παγκύπριο Δικηγορικό Σύλλογο. Τα προβλήματα στη δικαιοσύνη είναι πολλά και είναι γνωστά. Η δικαιοσύνη ουδέποτε ήταν στην πρώτη γραμμή προτεραιότητας της Κυπριακής Δημοκρατίας, εν μέρη γιατί ουδέποτε το πολιτικό μας σύστημα ήταν σε μια ομαλή κατάσταση, εν μέρη λόγω της τουρκικής εισβολής, αλλά και γιατί διαχρονικά υπήρξαν προβλήματα από το πολιτικό σύστημα της Κύπρου να αντιληφθεί τη σημασία του τομέα της δικαιοσύνης και για το κράτος και για την οικονομία της Κύπρου. Είμαι όμως παρά τα αυτά αισιόδοξος, γιατί υπάρχει τεράστια ποιότητα στο ανθρώπινο δυναμικό του δικηγορικού κόσμου. Και θα πω κάτι το οποίο ίσως ξενήσει. Εγώ πιστεύω ότι οι δικηγόροι είναι και έντιμοι και ικανοί και εργατικοί και εύριες γνώσεις έχουν και απόψεις και μπορούν να προσφέρουν τα μέγιστα όχι μόνο στη δικαιοσύνη, αλλά και ευρύτερα στον τομέα. Το ίδιο και ο Παγκύπριος Δικηγορικός Σύλλογος. Τείνουμε να υποτιμούμε το ρόλο του Παγκύπριου Δικηγορικού Συλλόγου και να μηδενίζουμε τις μέχρι σήμερα ενέργειες του. Μόνο από το 2018 έχει κληθεί σε 300 θέματα που συζητήθηκαν στην Επιτροπή Νομικών της Βουλής. Έκανε συναντήσεις με τον Πρόεδρο της Δημοκρατίας, με το Ανώτατο Δικαστήριο, με τους εκάστοτε υπουργούς δικαιοσύνης, με τον Γενικό Εισαγγελέα για διάφορα θέματα. Και πάντοτε οι απόψεις του Παγκύπριου Δικηγορικού Συλλόγου λαμβάνονται σοβαρά υπόψη. Δεν σημαίνει ότι στην περίπτωση εκείνη που κάποιος διαφωνεί μαζί μας θα πρέπει να οδηγούμε τα πράγματα στα άκρα και να θεωρούμε ότι αμέσως τίθεται ζήτημα τάξης. Τα προβλήματα που ταλανίζουν τον χώρο και τα θέματα που θα μας απασχολήσουν είναι γνωστά. Τα έχουν αναφέρει και οι συνάδελφοι και απλώς επιγραμματικά θα πω ότι σίγουρα είναι το θέμα της μεταρρύθμισης στη δικαιοσύνη, είναι το θέμα του Ταμείου Συντάξεως, είναι το θέμα της ηλεκτρονικής δικαιοσύνης και του ΣΑΙΛΟ, το θέμα των νέων και ασκούμενων δικηγόρων, η μείωση της δικηγορικής ύλης. Το ζητούμενο δεν είναι να βρίσκουμε εφάνταστες λύσεις και να έχουμε εφάνταστες ιδέες. Το ζητούμενο είναι να έχουμε μια σοβαρότητα, μια ρεαλιστική προσέγγιση των πραγμάτων. Να θυμίσω ότι ο Παγκύπριος Δικηγορικός Σύλλογος δεν έχει εκτελεστική αρμοδιότητα για τα περισσότερα από τα θέματα που μόλις έχουμε περιγράψει. Άρα, ο μόνος δρόμος είναι να χρησιμοποιηθεί και η γνώση και το κύρος του Παγκύπριου Δικηγορικού Συλλόγου και των δικηγόρων, ούτως ώστε σε συνεργασία με τους φορείς, και παρενθετικά αναφέρω ότι και οι τρεις εκπρόσωποι των φορέων στην Κύπρο στις δικές τους παρουσιάσεις έχουν τονίσει την ανάγκη για μεταρρυθμίσεις. Σε συνεργασία με αυτούς και με συνέπεια θα πρέπει να προχωρήσουμε για να πετύχουμε συνεχή βελτίωση. Μπορούμε να το κάνουμε αυτό? Φυσικά μπορούμε, αν είμαστε σωστοί και σε συνεργασία, ένα βήμα πάντα μπροστά, όχι όμως σε διαρκή ρήξη με αυτούς τους θεσμούς. Πρέπει να θυμίσω ότι το δικηγορικό επάγγελμα είναι και επάγγελμα αξιοπρέπειας και επάγγελμα μεγαλοπρέπειας. Πρέπει να σεβόμαστε τους θεσμούς, ούτως ώστε και αυτοί να μας σέβονται. Σας ευχαριστώ.
Σας ευχαριστούμε, κύριε Κορφιώτη. Όπως αντιλαμβανόμαστε, είναι παραδεικτό γεγονός ότι τα προβλήματα στο σύστημα της δικαιοσύνης είναι αρκετά. Θέλαμε όμως να μας πείτε ποια θεωρείτε ότι είναι τα σημαντικότερα και μεγαλύτερα προβλήματα στα οποία θα πρέπει να δοθεί προτεραιότητα. Να ξεκινήσουμε και πάλι με εσάς, κύριε Κληρίδη.
Κατ' εμέ δεν είναι μόνο το θέμα της καθυστέρησης της αποφάσης των δικαστηρίων και μιλούμε για μια πρωτόγνωρη καθυστέρηση. Είμεθα στον πάτο, να το βάλω έτσι, στην Ευρωπαϊκή Ένωση. Χρειάζεται περίπου 9 με 10 χρόνια να διεκπαιρεωθεί μια υπόθεση σε δύο επίπεδα, πρωτόδικα και στο εφετείο. Αλλά όπως ανέφερα και στην εισαγωγή μου, είναι και η ποιότητα των αποφάσεων και θα πρέπει να στοχεύσουμε στη βελτίωση της ποιότητας με τα μέτρα που έχω ήδη εισηγηθεί και αφορούν την προαγωγή και των διορισμών δικαστών στις ανώτατες δικαστικές θέσεις. Και εδώ οι δικηγόροι σαν λειτουργοί της δικαιοσύνης, όπως είναι και οι δικαστές, έχουν καθήκον, αλλά και το σύστημα πρέπει να τους προωθεί σε διορισμούς στις ανώτερες δικαστικές θέσεις των ανώτερων επαρχιακών, των προέδρων, των εφετών και στο ανώτατο δικαστήριο. Εκείνο όμως το οποίο θα ήθελα να σταθώ λίγο και θεωρώ ως πολύ σημαντικό, πέραν από τα όσα έχουν ακουστεί που είναι οι κτηριακές εγκαταστάσεις, που είναι τα μέτρα στήριξης των νέων δικηγόρων, για τα οποία έχω συγκεκριμένο πρόγραμμα, το οποίο δυστυχώς δεν μπορώ να αναλύσω τώρα, αλλά θα σταθώ στην αναγκαιότητα στήριξης των νέων δικηγόρων από τα μεγάλα δικηγορικά γραφεία με πολλούς τρόπους. Είναι το θέμα που αφορά την αναβάθμιση του ίδιου του ρόλου του δικηγόρου. Είναι μειωμένος ο δικηγόρος δυστυχώς τα τελευταία χρόνια, θεωρείται σαν ο τελευταίος τροχός της αμάξης και θα πρέπει βεβαίως να ενισχύσουμε των λειτουργών αυτών της δικαιοσύνης, γιατί η δικαιοσύνη χωρίς την συμμετοχή των δικηγόρων μαζικά σε όλα τα επίπεδα και πίστην σε αυτόν το αξιοπρεπές λειτουργήμα το οποίο ασκεί και στήριξη και ενθάρρυνση του, δεν υποβοηθά καθόλου το κράτος δικαίου, το οποίο βάλεται σήμερα πανταχώθεν. Συνεπώς, θα πρέπει η νέα ηγεσία του Παγκύπριου Δικηγορικού Συλλόγου να δώσει την έμφαση στη στήριξη του λειτουργού της δικαιοσύνης του δικηγόρου, αντιμετώπιση όλων των προβλημάτων τα οποία έχει, αλλά και της δικαιοσύνης. Ιδιαίτερα όσον αφορά τη στήριξη των δικηγόρων και με των μειωμένων όγκων υποθέσεων τις οποίες έχουμε αυτή τη στιγμή, θα πρέπει να δημιουργηθεί νέα ύλη. Και η Κύπρος εδώ είναι που θα μπορέσει να πάει μπροστά εν ώψη των προβλημάτων που αντιμετώπισε μέχρι σήμερα. Θα πρέπει να καταστεί κέντρον διαιτησίας. Θα πρέπει δηλαδή οι υποθέσεις αντί να φεύγουν από την Κύπρο και να πηγαίνουν σε διαιτησία στο Λονδίνο ή και σε άλλες χώρες, να πετύχουμε εμείς σαν λειτουργή της δικαιοσύνης με τις κατάλληλες όμως θεσμικές τροποποιήσεις και νομοθετικές αλλαγές να προσελκύσουμε τις διαφορές που έχουν κάποια διεθνή συνήθως πτυχή αλλά και σχέση με την Κύπρο να επιλύονται στην Κύπρο από λειτουργούς της δικαιοσύνης, από διαιτητές οι οποίοι είναι Κύπροι έμπειροι και ικανότατοι δικηγόροι.
Σας ευχαριστούμε κύριε Κληρή. Θα ακούσουμε τώρα τον κύριο Θεοδωρίδη.
Σε σχέση με τα προβλήματα των τομέων της δικαιοσύνης έχω ήδη αναφερθεί στην πρώτη τοποθέτησή μου. Όμως προκύπτει ξεκάθαρα ένα από τα βασικότερα προβλήματα που αντιμετωπίζουμε και εκεί φαίνεται να επικεντρώνονται και οι μεταρρυθμίσεις οι οποίες γίνονται τώρα και είναι προς ψήφιση και μελέτη, έχουν να κάνουν με τα διαχρονικά προβλήματα που έχουν συσσωρευτεί στα δικαστήρια. Ένα από τα μεγαλύτερα είναι δυστυχώς η καθυστέρηση η οποία προκύπτει στην εκδίκαση των υποθέσεων. Γεγονός το οποίο δεν τιμά κανέναν από όσους εμπλεκόμαστε στον τομέα αυτών και έχει οδηγήσει σε κάποιο βαθμό σε απαξίωση από το κοινωνικό σύνολο, καθώς επίσης λειτουργεί και ως αποτρεπτικός παράγοντας προς τον πολίτη να προσφύγει στα δικαστήρια. Θέλω να πω όμως ότι στις μεταρρυθμίσεις που γίνονται τώρα στο σύστημα το δικό μας, δεν πρέπει να επικεντρωθούμε ουσιαστικά μόνο στον τομέα των δικαστηρίων και να αναλύσουμε ακαδημαϊκά σε τόση έκταση το θέμα. Αν και είναι και σημαντικό και το οποίο ο Παγκύπριος Δικηγορικός Σύλλογος έχει ήδη θέσει τις απόψεις του από το 2018 κατά επανάληψη και συνεθέσεις μας όσον αφορά τον τομέα των δικαστηρίων. Μεταρρυθμίσεις πρέπει να γίνουν και στο σύστημα γενικότερα, όπως στην αναδιάρθρωση των θεσμών πολιτικής δικαιοσύνης, όπως γίνεται τα τελευταία 2 χρόνια, καθώς επίσης στην εφαρμογή και υλοποίηση της ηλεκτρονικής δικαιοσύνης που θα βοηθήσει τα μέγιστα τόσο στην ταχύτερη εκδίκαση των υποθέσεων, όσο και στην απλοποίηση των διαδικασιών, όσο και επίσης και στην αναβάθμιση, όπως έχω πει, των κτηριακών εγκαταστάσεων και την επάνδρωση των δικαστηρίων με προσωπικών πέραν από τους δικαστές, το οποίο είναι άκρως απαραίτητο, ώστε να βοηθά στη λειτουργία των δικαστηρίων. Αυτό συνίσταται στην πρόσληψη πρωτοκολλητών ή άλλου υπαλληλικού προσωπικού που είναι και εκείνο εξίσου σημαντικό. Τώρα, έχουμε κατά επανάληψη γίνει δέχτες στο σύστημα εισηγήσεων τόσο από το IPA της Ιρλανδίας όσο και από την Επιτροπή Γκρέκο του Συμβουλίου της Ευρώπης για θέματα που αφορούν το σύστημα των δικαστηρίων και πώς αυτό θα πρέπει να μεταρρυθμιστεί. Όπως έχω πει, ως Παγκύπριος Δικηγορικός Σύλλογος είχαμε διαχρονικά θέσει τις θέσεις μας, κάποιες από τις οποίες έχουν εισακουστεί και έχουν περιληφθεί στα νομοσχέδια, κάποιες από τις οποίες δυστυχώς δεν έχουν εισακουστεί. Θεωρώ ότι δεν είναι της ώρας τώρα να συζητήσουμε εν εκτάσει το θέμα αυτό, δεδομένου ότι τα νομοσχέδια έχουν επιστραφεί, θα τύχουν επεξεργασίας από τα πολιτικά κόμματα και από όλους τους εμπλεκόμενους φορείς. Επιμένω ότι η μεταρρύθμιση θα πρέπει να είναι σημαντική όσον αφορά τους θεσμούς πολιτικής δικονομίας. Θα πρέπει να γίνουν ευκολότερες και γρηγορότερες οι δικαστικές διαδικασίες. καθώς επίσης έμφαση πρέπει να δοθεί ώστε να εξευρεθούν τρόποι και να γίνουν ανάλογες τροποποιήσεις στην νομοθεσία ώστε η εκτέλεση των αποφάσεων να είναι αποτελεσματική. Είναι ένα θέμα να εκδικάσεις την υπόθεση που παίρνει 8 χρόνια όπως είπε ο Χρήστος και είναι άλλο θέμα να την εκτελέσεις. Τελικά η εκτέλεση είναι πιο δύσκολη από την έκδοση. Έχει καταστεί μηδενική εκτέλεση στην Κύπρο. Σε εμάς εναπόκειται μαζί με το Ανώτατο Δικαστήριο και το Υπουργείο Δικαιοσύνης να βρούμε τρόπους ούτως ώστε να το υλοποιήσουμε. Όσον αφορά τα κτίρια, είναι γνωστό το πρόβλημα. Θεωρώ ότι είναι δεδομένος η αναγκαιότητα εξυγχρονισμού, το οποίο θα βοηθήσει και στην εφαρμογή της ηλεκτρονικής δικαιοσύνης. Κάτι άλλο το οποίο να πω τελειώνοντας, είναι θεωρώ σημαντικό να προωθήσουμε και το θεσμό της διαμεσολάβησης. Ο οποίος θεσμός της διαμεσολάβησης από το 2012 που έχει θεσπιστεί σχετική νομοθεσία, δυστυχώς δεν έχει τύχει τόσης εφαρμογής. Ο θεσμός αυτός θα βοηθήσει στο να αποσυμφορηθούν τα δικαστήρια, θεωρώ. Ευχαριστώ.
Σας ευχαριστούμε κύριε Θεοδωρίδη. Να ακούσουμε τώρα τον κύριο Κορφιώτη.
Αυτό που είναι θετικό είναι ότι υπάρχει γενικότερη παραδοχή ότι χρειάζεται εξυγχρονισμός. Η μεταρρύθμιση η οποία συζητείται είναι η μεγαλύτερη από το 1964 και ουσιαστικά η μοναδική που συζητείται σε συνθήκες ομαλές. Διότι το 1964 πρόκειται για συνθήκες όπου ακολούθησαν την τουρκοκυπριακή αντασία και δεν ήταν ομαλές. Από μόνο του αυτόν το γεγονός είναι θετικό ότι οι φορείς έχουν ενσκύψει και συζητούν τα ζητήματα. Ο Παγκύπριος Δικηγορικός Σύλλογος συμμετείχε στην διάρκεια των διαβουλεύσεων για την μεταρρύθμιση, υπέβαλε προτάσεις και ενημέρωνε τα μέλη του για τα τεκτενόμενα. Μάλιστα έγινε μια εξαιρετική γενική συνέλευση των δικηγόρων πριν λίγους μήνες, όπου πραγματικά έγινε μια συζήτηση υψηλού επίπεδου και πάρα πολλοί συνάδελφοι εξέφρασαν απόψεις για τα συζητούμενα νομοσχέδια. Θεωρώ ότι τα νομοσχέδια αυτά βρίσκονται προς την σωστή κατεύθυνση. Γιατί οδηγούμαστε στην εφαρμογή και επαναφορά των διατάξεων του συντάγματος, τη δημιουργία τρίτου βαθμού δικαιοδοσίας, τη δημιουργία εφετείου που θα απαρτίζεται από 16 εφέτες οι οποίοι θα οργανωθούν σε διάφορα τμήματα και εξειδικεύσεις, πράγμα το οποίο κατά την άποψή μου θα οδηγήσει στον εξυγχρονισμό του συστήματος, θα βοηθήσει στο τεράστιο πρόβλημα που δεν χρειάζεται να το επαναλάβω της καθυστέρησης στην απονομή της δικαιοσύνης και επίσης ελπίζουμε ότι θα οδηγήσει σε εξυγχρονισμό και της νομολογίας και στο ξεκαθάρισμα διαφόρων νομικών θεμάτων τα οποία σήμερα απασχολούν τον νομικό κόσμο. Μέσα στις πρόνοιες του νομοσχεδίου είναι και η πρόνοια για την αλλαγή στη σύνθεση του Δικαστικού Συμβουλίου. Ήταν συνεχής η άποψη του Παγκύπριου Δικηγορικού Συλλόγου ότι το Δικαστικό Συμβούλιο θα πρέπει να εμπλουτιστεί. Ήταν επίσης και η άποψη και η Συμβουλή της Γκρέκο και μέσα στο Δικαστικό Συμβούλιο το οποίο προτείνεται έχουμε τη συμμετοχή και επαρχιακών δικαστών και δικηγόρων, του Προέδρου του Παγκύπριου Δικηγορικού Συλλόγου και ενός έμπειρου άλλου δικηγόρου. Θεωρώ ότι αυτή η τροποποίηση είναι κατάκτηση του Δικηγορικού Συλλόγου. Με χαρά άκουσα προηγουμένως τον Πρόεδρο του Ανωτάτου Δικαστηρίου να συμφωνεί με αυτή τη ρύθμιση και νομίζω ότι θα οδηγήσει σε καλύτερους δρόμους. Θα ήθελα να πω και δύο λόγια για το θέμα των δικαστών, το οποίο είχε αναφέρει και προηγουμένως ο κ. Τιγρής. Έχω μια ξεκάθαρη θέση, την οποία εξέφρασα σε διάφορες περιπτώσεις στο παρελθόν και στο ίδιο το Ανώτατο Δικαστήριο και στους Υπουργούς Δικαιοσύνης. Για κάθε διορισμό δικαστή θα πρέπει να διορίζεται ο καλύτερος, ο καταλληλότερος, με διαφάνεια, ανεξαρτήτως του εάν προέρχεται από την μαχόμενη δικηγορία ή από το χώρο των δικαστηρίων. Είμαι ξεκάθαρος σε αυτό. Όλοι οι δικαστές ασκούν δικαστική εξουσία, ασκούν δημόσια εξουσία, διαμορφώνουν δικαιώματα και υποχρεώσεις σε όλα τα πεδία του δικαίου. Από τον πρόεδρο του Ανωτάτου Δικαστηρίου μέχρι και τον τελευταίο νεοδιόριστον επαρχιακό δικαστή θα πρέπει να υπάρχει υψηλή ποιότητα στους δικαστές. Εμείς οι δικηγόροι θα πρέπει βεβαίως να είμαστε αρρωγοί και όχι κακόπιστοι κριτές, αλλά καλόπιστοι κριτές. Αν αυτό το σύστημα εφαρμοστεί σωστά, πιστεύω ότι θα έρθουν καλύτερες μέρες για την δικαιοσύνη στην Κύπρο. Αν εφαρμοστεί λαθασμένα, μπορεί και να καταστρέψουμε αυτό που πάμε να αρχίσουμε.
Σας ευχαριστώ κύριε Κορφιώτη, αλλά επειδή οι αναφορές σας είχαν να κάνουν σχέση και με κάποιες αποφάσεις, θα ήθελα να πάμε λίγο πίσω να υπενθυμίσουμε τις πρόσφατες καταγγελίες που είχαν να κάνουν με την διαπλοκή και οι οποίες έπληξαν κατά κάποιον τρόπο τον θεσμό της δικαιοσύνης. Θεωρείτε ότι υπάρχει διαπλοκή, θεωρείτε ότι το σύστημα είναι αξιόπιστο? Πώς το σχολιάζετε όλο αυτό? Γιατί οι αιχμές που είχαν υποθεί και είχαν αναφερθεί τότε συνεχίζουν και μέχρι σήμερα.
Αν μπορώ να απαντήσω πρώτος, εφόσον ακολουθούμε τη σειρά αυτή, να πω καταρχάς ότι εγώ διαφωνώ ότι η τροποποίηση, η μεταρρύθμιση όπως είναι αυτή τη στιγμή είναι ικανοποιητική. Δεν συμμερίζομαι αυτή την άποψη και νομίζω ότι η πλειοψηφία του δικηγορικού σώματος δεν τη συμμερίζεται. Καταρχάς, δεν υλοποιούνται οι προτάσεις των Ιρλανδών, τις οποίες χρηματοδότησε η Ευρωπαϊκή Ένωση για τη μεταρρύθμιση. Ένα μέρος των προτάσεων μόνον υλοποιείται και οι Ιρλανδοί μας τόνισαν ότι πρέπει να αποφύγουμε το cherry picking, δηλαδή την επιλογή. Επιπρόσθετα, όσον αφορά την Γενική Συνέλευση των Δικηγόρων, εγώ έχω ακούσει πάρα πολλά παράπονα ότι η πλειοψηφία των δικηγόρων δεν είχε παραστεί και δεν ήταν ενήμεροι και δεν είναι ακόμα σήμερα ενήμεροι με τις προτινόμενες μεταρρυθμίσεις. Η διαπλοκή. Ναι, έχουμε σοβαρές καταγγελίες. Εγώ ακόμη και ψες είχα καταγγελία από έμπειρων δικηγόρων για διαπλοκή. Συνεχώς υπάρχουν αυτά τα προβλήματα και είναι για αυτόν τον τρόπο που θα προσπαθήσω να δημιουργήσω μία επιτροπή, Watchdog Committee, του Παγκύπριου Δικηγορικού Συλλόγου, η οποία θα γίνεται δέχτης αυτών των καταγγελιών, δέχτης αυτών των παραπώνων και αξιόπιστα, με εγκυρότητα, με εμπιστευτικότητα θα εξετάζει αυτές τις καταγγελίες με στόχο να λαμβάνει τα μέτρα όπου χρειάζεται για να διορθώνει την κατάσταση. Δεν έχουμε ξεπεράσει την κρίση, μπορώ να πω, Ιανουαρίου του 2019, με συγχωρείτε. Παραμένει η αρχή ότι η δικαιοσύνη δεν πρέπει μόνο να απονέμεται, αλλά να φαίνεται ότι απονέμεται και δυστυχώς δεν έχουμε κερδίσει την εμπιστοσύνη του κοινού σε αυτήν την αρχή. Άρα θα πρέπει μέσα στο πλαίσιο της μεταρρύθμισης να ληφθούν και πρόσθετα μέτρα που είναι αυτά τα οποία εισηγήθηκα στην εισαγωγή μου, τα οποία θα είναι προς την κατεύθυνση επαναφοράς της εμπιστοσύνης του μέσου Κυπρίου, εχέφρονα Κυπρίου, στο θεσμό που ονομάζεται δικαιοσύνη. Δεν είναι θέμα μόνο καθυστερήσεων. Είναι και θέμα ακριβώς ποιότητας και να βγαίνει προς τα έξω η εικόνα της πλήρους αμεροληψίας. Επί τούτου θα καταβάλω το άπαντο δυνάμιο μου για να το επιτύχουμε. Είναι πολύ σημαντικό.
Σας ευχαριστούμε κύριε Κληρίδη. Να ακούσουμε τώρα τον κύριο Θοδωρίδη ποια είναι η άποψή του σε σχέση με τις αναφορές περί διαπλοκής και πώς μπορούν να διορθωθούν αυτά τα όλα όσα λέγονται κατά διαστήματα.
Δυστυχώς θα διαφωνήσω με τον φίλτερο συνάδελφο μου, τον κύριο Κληρίδη. Εγώ δεν δέχομαι ότι υπάρχει διαπλοκή στο δικαστικό μας σύστημα. Αντίθετα, τα 27 χρόνια που ασκώ το δικηγορικό επάγγελμα, η προσωπική μου άποψη, και θεωρώ ότι είναι και άποψη πολλών συναδελφών, είναι ότι παρά τα προβλήματα που υπάρχουν στην καθυστέρηση έκδοσης των αποφάσεων, παρά τα διάφορα προβλήματα που υπάρχουν στη διοίκηση των δικαστηρίων, παρά τα προβλήματα που υπάρχουν, όπως λέγεται, στη διαφάνεια σε σχέση με τις προαγωγές των διορισμών και λοιπά των δικαστηρίων, των δικαστών, που ήταν και αντικείμενο που είναι και ακόμα αντικείμενο μεταρρυθμίσεων, θεωρώ ότι η απονομή της δικαιοσύνης στην Κύπρο, ειδικά από τα δικαστήρια, είναι σε πολύ ψηλό επίπεδο. Τώρα, αν διαφωνούμε σε κάποιες αποφάσεις που λαμβάνονται, είναι ένα θέμα. Όμως, είμαι κάθετος και δεν δέχομαι ότι υπάρχει διαπλοκή στο σύστημα απονομής δικαιοσύνης. Είναι άδικο προς τους δικαστές να τους αποδίδουμε αυτό το θέμα. Και εγώ είμαι εξ εκείνων που πιστεύω ότι πρέπει να γίνουν ρυθμίσεις και μεταρρυθμίσεις. Είμαι εξ εκείνων που πιστεύω ότι το εφετείο, όπως θα γίνει, εάν πάνε οι 16 εφέτες απευθείας από τα επαρχιακά δικαστήρια, θα έχουμε σοβαρό πρόβλημα στα ίδια τα δικαστήρια, αλλά δεν μπορώ να δεχτώ το θέμα της διαπλοκής. Είναι ένα θέμα να διαφωνείς, είναι ένα άλλο θέμα να λες ότι υπάρχει διαπλοκή. Η καλόπιστη κριτική, συμφωνώ με τον Θανάσιο προηγουμένως, είναι και θεμιτή και πρέπει να υπάρχει. Σαφέστατα και έχουμε κάποιο θέμα με την ποιότητα των αποφάσεων. Φυσικά οι αποφάσεις, όπως κρίνονται υποκειμενικά από τον δικηγόρο. Για να είμαστε ειλικρινείς, αν κερδίσουμε την υπόθεση, μας αρέσει. Αν τη χάσουμε, πιθανόν να μην μας αρέσει. Όμως δεν μπορώ να δεχτώ το θέμα της διαπλοκής. Όσον αφορά τις μεταρρυθμίσεις, πάλι θα διαφωνήσω με τον Χρήστο. Η ενημέρωση υπήρχε. Έχω εδώ μπροστά μου επιστολές από τον Ιούλιο του 2018 που υπογράφονται από τον πρόεδρο των Δώρων τον Ιωαννίδη, όπου αποτίθενται ξεκάθαρα οι θέσεις και οι ανησυχίες του Παγκυπρίου. Παρευρέθηκα μαζί με τον κύριο Ιωαννίδη, τον Θανάσιο, τον Κορφιώτη και άλλους συναδέλφους στο Προεδρικό σε συνεδρίαση με τον πρόεδρο της Δημοκρατίας, που τέθηκαν ξανά οι προβληματισμοί μας. Με κάποιους εκ των οποίων συμφώνησε ο πρόεδρος. Κάποιοι από τους προβληματισμούς μας δυστυχώς δεν λήφθηκαν υπόψη. Γι' αυτό και επιμένουμε και είμαστε κάθετοι, και θεωρώ και εγώ και το Συμβούλιο, αν εκλεγούμε, πώς θα το χειριστούμε, ότι πρέπει να έχουμε ρόλο και άποψη ως δικηγορικός κόσμος. Γιατί είμαστε οι πρώτοι που επηρεάζονται σαφέστατα από αυτές τις μεταρρυθμίσεις. Ευχαριστώ.
Κύριε Κορφιώτη, να ακούσουμε και τη δική σας θέση.
Είμαι και εγώ ξεκάθαρος, όπως ήταν και ο Κυριάκος. Δεν υπάρχει θέμα διαπλοκής στην κυπριακή δικαιοσύνη. Τουλάχιστον με την έννοια που άφησε να εννοηθεί ο κύριος Κληρίδης. Και μου προκάλεσε εντύπωση η αναφορά του ότι ψες από έμπειρο δικηγόρων είχε πληροφόρηση για θέμα διαπλοκής στη δικαιοσύνη. Αν υπάρχει τέτοιο πράγμα, θεωρώ ότι οφείλει να το αναφέρει και να το καταγγείλει στην αστυνομία. Είμαστε όλοι υπηρέτες ενός θεσμού. Λειτουργούμε και οι δικηγόροι και οι δικαστές πολλές φορές κάτω από άθλιες συνθήκες, ιδιαίτερα στο Επαρχιακό Δικαστήριο Λευκωσίας, και ουδής από αυτούς τους δύο φορείς δεν θέλει να έχει μια στάση η οποία θα βλάψει τη δικαιοσύνη. Λάθος αποφάσεις πάντα θα εκδίδονται, όπως λάθος θέσεις ή λάθος επιχειρήματα, που είναι εν πάση περιπτώσει υποκειμενικά, όπως είπε και ο Κυριάκος πολλές φορές, εγείρουμε και εμείς οι δικηγόροι. Δεν επέρασε ποτέ από το μυαλό μου στα χρόνια άσκησης δικηγορίας, σε όλα τα δικαστήρια, στα ανώτατα, στα επαρχιακά, στο ποινικό, στο αστικό, ότι ο δικαστής εξέδωσε μία απόφαση η οποία έχει οποιοδήποτε άλλο στόχο από το να επιλύσει δίκαια τη διαφορά. Είναι πολύ διαφορετικό το ένα από το άλλο. Και ο Παγκύπριος Δικηγορικός Σύλλογος, πιστεύω στην κρίση τότε, κράτησε μια πολύ σοβαρή στάση, προστάτευσε την δικαιοσύνη και προστάτευσε και τους δύο θεσμούς του Ανωτάτου Δικαστηρίου και του θεσμού του Γενικού Εισαγγελέα, οι οποίοι είχαν τη σύγκρουση. Αν υπάρχει θέμα διαφθοράς, είμαι κάθετος. Πρέπει αμέσως να παταχθεί. Όμως δεν θεωρώ ότι στην Κύπρο έχουμε θέμα διαφθοράς.
Σας ευχαριστούμε κύριε Κορφιώτη. Να αλλάξουμε τώρα κεφάλαιο και να πάμε σε ένα άλλο ζήτημα στο οποίο επίσης ο ρόλος των δικηγορικών γραφείων είναι αρκετά σημαντικός. Η Κύπρος είναι ένα επιχειρηματικό και χρηματοοικονομικό διεθνές κέντρο το οποίο παρέχει υπηρεσίες σε ξένους. Θα θέλαμε να μας πείτε την άποψή σας για το πόσο σημαντικός είναι ο ρόλος των δικηγόρων και ποιες ενέργειες θα μπορούσαν να γίνουν ώστε αυτό το διεθνές κέντρο να βελτιωθεί ακόμη περισσότερο.
Χαίρομαι καταρχάς για την συζήτηση, διότι μέσα από τη συζήτηση βγαίνει και η διαφορά μου ακριβώς με τους δύο ανθυποψηφίους μου. Ο ίδιος ο Γενικός Εισαγγελέας μίλησε ο πρώην για διαπλοκή. Δεν μπορεί να διαψεύδουμε και τον πρώην Γενικό Εισαγγελέα. Να θυμίσω πρωτοσέλιδα εφημερίδων, ρεπορτάζ δημοσιογράφων, τα θυμάστε πολύ καλά, γιατί είστε στον τομέα και δεν νομίζω ότι έχουμε ξεπεράσει την κρίση εκείνη. Πρέπει ναήμεθα ειλικρινείς με τους εαυτούς μας, εάν θέλουμε να λύσουμε τα προβλήματα της δικαιοσύνης. Όχι μόνο τα τεχνικά θέματα, τις κτηριακές εγκαταστάσεις και όλα αυτά για τα οποία όλοι νομίζω έχουμε άποψη και θα ενεργήσουμε, αλλά και τα θέματα ουσίας. Και ευχαριστώ γιατί μέσα από αυτό το πρόγραμμα, με αυτό το συνέδριο, δόθηκε η ευκαιρία να βγουν ακριβώς οι διαφορές, όπως είπα, μεταξύ μου και των ανθυποψηφίων. Τώρα, πώς μπορούμε να επαναφέρουμε την Κύπρο στο διεθνές προσκήνιο όσον αφορά τις υπηρεσίες? Έχει υποστεί τεράστια πλήγματα η Κύπρος. Να υπενθυμίσω ότι οι offshore, οι υπεράκτιες εταιρείες που κάποτε ήταν το κέντρο δραστηριότητας και των δικηγορικών γραφείων, πολύ εισοδηματικά επιτυχής εργασία, αλλά και για την κυπριακή οικονομία, δεν υπάρχει πλέον. Στη συνέχεια το τραπεζιτικό σύστημα δυστυχώς κατέρευσε το 2013. Δεν θα εξηγήσω τους λόγους τώρα και ποιοι φέρουν την ευθύνη για αυτά. Πάντως δεν είναι οι δικηγόροι οι οποίοι έφεραν την κατάρρευση. Είναι άλλοι. Μπορεί κάποια σάπια μήλα να συνέτειναν από το δικό μας το επάγγελμα. Τώρα πού προχωρούμε? Τα διαβατήρια φαίνεται ότι και αυτά παραπέουν και δεν αμφιβάλλω ότι πολύ σύντομα η ίδια η Ευρωπαϊκή Ένωση θα ζητήσει από όλα τα κράτη-μέλη και όχι μόνο από την Κύπρο να καταργήσουν το θεσμό αυτό ή να τεθεί υπό ακόμα πιο αυστηρόν έλεγχο. Νομίζω ότι η μόνη διέξοδος που έχει τώρα το επάγγελμα αλλά και η οικονομία της Κύπρου να καταστεί πλέον κέντρο προσέλκυσης επενδύσεων και εισοδημάτων είναι με αυτό που είχα πει προηγουμένως. Να γίνει η Κύπρος κέντρος διαιτησίας, διεθνών διαιτησιών. Και βεβαίως είναι με μεγάλη μου λύπη που βλέπω ότι κάποια μέτρα τα οποία υπάρχουν στη μεταρρύθμιση δεν συντείνουν προς αυτήν την κατεύθυνση. Παραδείγματος χάρη, πάμε να κάνουμε έναν εμπορικό δικαστήριο και απαγορεύουμε τη χρήση της αγγλικής γλώσσας. Ποιος θα έρθει στο εμπορικό δικαστήριο εκτός από αυτούς που έχουν άμεσα εμπλοκή στην Κύπρο να εκδικάσει μια υπόθεση, εάν η γλώσσα είναι αποκλειστικά στα ελληνικά? Και γιατί να το έχουμε αυτόν υποχρεωτικό, αν οι διάδικοι συμφωνούν μεταξύ τους ότι μπορεί να χρησιμοποιηθεί η αγγλική γλώσσα? Είναι με αυτόν τον τρόπο που χάσαμε, να υπενθυμίσω, το Admiralty των αυτοδικείων, που ενώ μέχρι το 1989 αποφάσεις ακόμα εκδίδονται και η διαδικασία ήταν στα αγγλικά, μετετράπην υποχρεωτικά στα ελληνικά. Για ορισμένους τομείς δεν πρέπει να βλέπουμε το θέμα εθνικά ή εθνικιστικά ή γλωσσικά. Πρέπει να διευκολύνουμε ακριβώς τον τρόπο λειτουργίας της δικαιοσύνης, των δικηγορικών γραφείων και να προσελκύσουμε και εμείς ήδη οι δικηγόροι μέσα από ρήτρες παρεκτάσεως στις οποίες θα πρέπει να συμπεριλαμβάνουμε στα συμβόλαια τα οποία κάνουμε με τους πελάτες μας την διαιτησία στην Κύπρο και την παραπομπή των διαφορών στο το νέο εμπορικό δικαστήριο το οποίο θα είναι στην Κύπρο. Είναι η μόνη διέξοδος αυτή τη στιγμή που βλέπω ότι θα βοηθήσει όντως την κυπριακή οικονομία αλλά και το επάγγελμα.
Σας ευχαριστούμε πολύ κύριε Κληρίδη. Να δώσουμε τώρα τον λόγο στον κύριο Θεοδωρίδη.
Παρά το γεγονός ότι διαφώνησα προηγουμένως με τον Χρήστο για τα θέματα της διαπλογής, συμφωνώ απόλυτα στο τι έχει πει όσον αφορά την πρόθεση του δικηγορού επαγγέλματος στο εξωτερικό. Αν καταφέρουμε να καταστήσουμε την Κύπρο ως κέντρο διεθνής ζητησίας, θα είναι πολύ ευτυχές και θα υποφέρει αρκετή ύλη στον τόπο μας. Τα ίδια ισχύουν για το εμπορικό δικαστήριο. Πρέπει να πω ότι ο ρόλος του δικηγορικού επαγγέλματος στο να καταστεί η Κύπρος ή να συνεχίσει να είναι διεθνής κέντρο υπηρεσιών είναι πολύ σημαντικός. Υπάρχουν αρκετοί συνάδελφοι οι οποίοι έχουν ισχυρών εκπαιδευτικών υποβαθρών και έχουν γεγονός τους οποίους τους καθιστά ανταγωνιστικούς διεθνώς. Επίσης, πολλά δικηγορικά γραφεία κυπριακά με χαρά να ακούμε ότι είναι δημοφιλείς στις διάφορες εργασίες που γίνονται στο εξωτερικό και ειδικά έχουμε συναδέλφους οι οποίοι ειδικεύονται στο εμπορικό, στο εταιρικό δίκαιο, στο φορολογικό δίκαιο, καθώς επίσης και στο θέματα που αφορούν χρηματοοικονομικά μέσα. Ως επάγγελμα έχουμε βοηθήσει, πιστεύω, τα τελευταία χρόνια να καταστεί η Κύπρος ένα κέντρο προορισμού επενδυτικών ταμείων και επίσης πολλές εταιρείες να επιλέγουν την Κύπρο ώστε να εγκαταστήσουν την έδρα των υπηρεσιών τους ή μέρος αυτών. Είναι γεγονός ότι ο θεσμός των υπεράκτιων εταιριών την είναι εκλείψει. Είμαστε από τις τυχερές χώρες που είχαμε καταφέρει να έχουμε έναν εκτεταμένο δίκτυο συμφωνιών για αποφυγή διπλής φορολογίας, αλλά είχαμε εξαρτηθεί σε συγκεκριμένες χώρες. Είναι καιρός να επεκταθούμε και σε άλλες χώρες όσον αφορά αυτόν τον τομέα, ειδικότερα σε χώρες της Κεντρικής Ευρώπης και στην Άπο Ανατολή. Εμείς ως δικηγόροι πρέπει να συμβάλλουμε στον τομέα αυτό. Έχουμε την υποχρέωση να αντιλαμβανόμαστε τις απαιτήσεις των πελατών μας, να ενεργούμε με πλήρη διαφάνεια, με καλή ποιότητα υπηρεσιών, ούτως ώστε αντιλαμβανόμενοι τις ανάγκες τους να τους βοηθούμε να εξυπηρετούν πάντα εντός της νομιμότητας. Κάποια θέματα που προκύπτουν τελευταίως όσον αφορά την αξιοπιστία της χώρας μας θα μπορούσαν κάλλιστα να εξαλειφθούν εάν όλοι που ασχολούμαστε με τον χώρο των υπηρεσιών τηρούσαμε με ευλάβεια το νομικό πλαίσιο που αφορά την εποπτεία και την συμμόρφωση με την νομοθεσία για την παρεμπόδιση ξεπλήματος χρήματος από παράνομες δραστηριότητες. Χρήζει επίσης να γίνει εξυγχρονισμός σε διάφορες υπηρεσίες της δημοκρατίας, καθώς επίσης να αποφύγουμε τη γραφειοκρατία η οποία εμποδίζει τους επενδυτές ώστε να προχωρήσουν με ταχύς ρυθμούς στις επενδύσεις τους. Και σε αυτόν τον τομέα η μεταρρύθμιση στη δικαιοσύνη θα βοηθήσει τα μέγιστα. Διότι ένας επενδυτής ο οποίος θα έρθει στην Κύπρο πρέπει να είναι βέβαιος ή να είναι πεπισμένος τουλάχιστον ότι εάν υπάρχει οποιοδήποτε πρόβλημα, κάποια διαφορά με την επένδυση του, η διαφορά του θα εκδικαστεί και γρήγορα και αν έχει και απόφαση να μπορεί να την εκτελέσει. Αν υπάρχει ανησυχία ότι είτε δεν θα εκδικαστεί είτε δεν θα εκτελεστεί, τότε δυστυχώς αποθαρρύνουμε τους επενδυτές. Σε εμάς εξαρτάται, στους επαγγελματίες παροχής υπηρεσιών και τους δικηγόρους μεταξύ άλλων, να προβάλλουμε τα καλά της χώρας μας, τα συγκριτικά πλεονεκτήματα που έχουμε με άλλες χώρες, ούτως ώστε να προσελκύσουμε ξανά τους πελάτες πίσω και να επανακτήσουμε την αξιοπιστία της χώρας μας σε αυτόν τον τομέα.
Σας ευχαριστούμε πολύ. Κύριε Κορφιώτη.
Περίπου οι μισοί δικηγόροι, αν όχι περισσότεροι, που ασκούν δικηγορία, ασχολούνται με εξωδικαστηριακές υπηρεσίες. Και νομίζω καταχρηστικά μιλούμε για μάχημη δικηγορία εννοώντας τους δικηγόρους των δικαστηρίων, διότι μάχημοι είναι και οι συνάδελφοι οι οποίοι ασχολούνται με τον τομέα των εξωδικαστηριακών υπηρεσιών, ο οποίος παρά τα προβλήματα ή παρά τα αρνητικά δημοσιεύματα, είναι ένας τομέας ο οποίος βοήθησε τα μέγιστα την κυπριακή οικονομία διαχρονικά. Και δεν είναι μόνο το θέμα της εισρωής ξένων κεφαλαίων στην Κύπρο, είναι και το θέμα, ειδικά για το επάγγελμα μας, του ότι πολλά δικηγορικά γραφεία, πολλοί συνάδελφοι έχουν εξειδικευθεί στον τομέα αυτό, επειδή ακριβώς αναγκάστηκαν να ανεβούν στο επίπεδο των αντίστοιχων γραφείων σε πολύ ανεπτυγμένες χώρες του κόσμου και να εφαρμόσουν σύγχρονες τεχνολογίες στην άσκηση της δικηγορίας και ούτω καθεξής. Τα τελευταία χρόνια έχει αλλάξει αυτό το τοπίο και φυσικά έχουμε και εμείς τις δικές μας ευθύνες. Βασικό πρόβλημα κατά την άποψη μου είναι το γεγονός ότι έχουμε στοχεύσει στο εύκολο και γρήγορο κέρδος παρά σε μία πιο μεσοπρόθεσμη και μακροπρόθεσμη προσέγγιση αυτών των εργασιών, πράγμα το οποίο έστω καθυστερημένα πιστεύω ότι πρέπει να κάνουμε αυτή τη στιγμή. Ας πούμε, έχουμε έναν εξαιρετικό νομικό πλαίσιο για τα αμοιβαία κεφάλαια, το οποίο όμως δεν το έχουμε εφαρμόσει ορθόδοξα και στην ουσία χρησιμοποιούμε τα αμοιβαία κεφάλαια ως εάν να ήταν μια απλή εταιρεία περιορισμένης ευθύνης με ένα ξένο επενδυτή.
Let me welcome you back for the last session of the day and introduce my colleague, Dr. Skliarchos Kyriakidis, Assistant Professor and Deputy Head of the School of Law of Euclid, Cyprus. He will be presenting on the criticality of risk assessment and what we can learn from various reports of inquiry in the UK.
I begin by expressing my gratitude to IMH for giving me this opportunity to address its second annual Cyprus Legal Conference. Over the next 10 minutes or so, what I'd like to do is address three somewhat interlinked lessons of British history with potentially profound implications for the Republic of Cyprus, its legal profession and wider society. These three lessons of history concern the criticality of vigilance, the criticality of culture, and the criticality of risk assessment, together with the overall process of risk management, that risk assessment is inextricably entwined. Each of these three lessons of history emerges from one or more official reports of inquiry published in the United Kingdom. That is the European island state where I spent the first 45 years of my life before relocating to another European island state, the Republic of Cyprus, where I relocated in 2015. Now, let me now turn to the first lesson of history, which, as I said, relates to the criticality of vigilance. That word vigilance translates into Greek as epagribnisi. More to the point, to build an old saying, eternal vigilance is not only the price of freedom, but the price of sustained health, safety, and security as well. This is because every person, and indeed every organization, may be just a moment away from suddenly being caught up in a potential or an actual catastrophe involving the loss of human life, the loss of human dignity, or some other malign consequence with grave implications for the rule of law, the right to life, and other fundamental rights and freedoms. In truly horrific circumstances, this first lesson of history was highlighted in London on the 14th of June 2017, when a fire suddenly broke out in and rapidly engulfed Grenfell Tower. That is, or rather was, a densely populated 24-storey block of residential flats, the construction of which was originally completed in, of all years, 1974. The inferno at Grenfell Tower led to the premature death of 72 people and the commission by the then British Prime Minister, Theresa May, of a public inquiry chaired by Sir Martin Moore-Bick, a retired judge of the Court of Appeal of England and Wales. On the 30th of October 2019, Her Majesty's Stationery Office published the Phase 1 report of the public inquiry into the fire at Grenfell Tower on the 14th of June 2017, to give the report its full name. This report conveys observations, lessons, and recommendations which, I would tentatively suggest, may be relevant to the Republic of Cyprus, its legal profession, its construction industry, and its emergency services, as well as wider society. I say that in part because the Republic of Cyprus is prone to fires, including forest fires, as well as earthquakes and other sources of grave danger, such as explosions, as we discovered with the Marie catastrophe in 2011. There's another reason, however, why the report of the first Phase 1 report of the Grenfell Tower inquiry is so potentially relevant to the Republic of Cyprus. And this is because in recent years its cities have become peppered with skyscrapers and other high-rise buildings. The Phase 1 Grenfell Tower report, which I repeat was published on the 30th of October 2019, delivers potentially life-saving recommendations and other messages on what it depicts as contingency evacuation plans, personal emergency evacuation plans, means of escape, fire lifts and firefighting lifts. I will go no further other than to make the obvious point that this report really ought to be required reading in the Republic of Cyprus in order to help inform its health, safety and security culture. I hope it already is part of that culture, but if it isn't, I encourage everybody who's viewing this film to act upon that report by, at the very least, reading it and implementing any of its recommendations which may be applicable to the Republic. My second lesson of history concerns the criticality of culture. On the surface, an organisation and everything in an organisation may appear to be in order. However, on closer inspection, there may be an unethical culture or another deeply embedded problem of a systemic nature that is difficult to detect but inherently capable of causing a catastrophe or crisis. This second lesson of history leaps out from one report of inquiry after another in the United Kingdom. A good example is the Staffordshire National Health Service Foundation Trust public inquiry, which was a report of inquiry written by the chair of the inquiry, Robert Francis QC, now Sir Robert Francis QC. In the executive summary, Mr. Francis QC, as he was then known, referred to the appalling suffering of many patients at Stafford Hospital during the period under examination by his inquiry. Mr. Francis QC also found that the board of the now dissolved Mid Staffordshire NHS Foundation Trust, which was legally responsible for Stafford Hospital, had, and I'm quoting here, failed to tackle an insidious negative culture involving a tolerance of poor standards and a disengagement from managerial and leadership responsibilities. In the related criminal case, which arose as a consequence of this scandal, in which the trust pleaded guilty to breaching the Health and Safety at Work, etc. Act, Mr. Justice Haddon Cave, as Lord Justice Haddon Cave was then known, referred to an underlying system of work. The same judge also pointed to the report of Mr. Francis QC, and in that context observed there was a focus on financial issues at the expense of the quality of service delivered. And those were the sentencing remarks in one of a number of criminal cases in which the trust pleaded guilty and was sentenced. Now, with all that in mind, I ask a very simple question. How many organisations in the public and private sectors of the Republic of Cyprus suffer from either an unethical fixation with financial issues or an unsafe system of work, or both? Whatever the answer may be, if any organisation is subject to either of those two, in other words, an unethical culture or an unsafe system, it must change for the better before it is too late. The third lesson of history flows naturally from the first two and concerns the criticality of risk assessment and, by extension, risk management. What various reports of inquiry expressly or impliedly affirm is the importance of timely, accurate, effective, and otherwise appropriate risk assessments. What is a risk assessment? Well, the basic definition is set out in the Cambridge Dictionary. It's the process of finding out how much risk is involved in doing something. But a risk assessment may involve assessing how much risk is involved in a particular venue or in a particular project or something else for that matter. So it's much broader than the very narrow dictionary definition. What is its purpose? Well, this is perhaps the critical issue. What is the purpose of risk assessment? Was one of the questions considered in December 1919 in Volume 1 of the Thames Safety Inquiry Interim Report by Lord Justice Clerk, as Lord Clerk of Stonecombe Ebony, a future Master of the Rolls and Justice of the Supreme Court of the United Kingdom was then known. The Thames Safety Inquiry arose in belated response to what occurred in the River Thames on the 20th of August 1989, when a total of 51 lives were lost after what Lord Justice Clerk depicted as the collision between the passenger vessel Marchioness and the dredger Bow Bell. Against that background, Lord Justice Clerk said the following, which was subsequently cited with approval by Mr. Justice Forbes in his judgment handed down in the High Court of England and Wales in the case of Davis and Stenerline, which was reported in 2005. So this is what Lord Justice Clerk said about the purpose of risk assessment. The purpose of risk assessment is to try to assess relevant risks in advance so that appropriate steps can be taken to put measures in place to eliminate or minimize them. I'll repeat that. The purpose of risk assessment is to try to assess relevant risks in advance so that appropriate steps can be taken to put measures in place in order to eliminate or minimize them. To sum up, the Republic of Cyprus has much to learn from what has gone wrong in the United Kingdom in places such as Grenfell Tower, Stafford Hospital and the River Thames. It's likewise clear that risk assessment and by extension risk management are among the keys to health, safety and security, not just for every organisation, but I would suggest for every individual as well. In a law firm, risk assessment and risk management will also constitute keys to compliance with the principles of professional ethics, any related code of conduct, and the duties imposed by laws, such as those connected with anti-money laundering, terrorist financing, and, dare I say it, the COVID-19 pandemic. Finally, in the interests of what might be called personal as well as organisational risk management literacy, I encourage every attendee at this conference, if they have not already done so, to read the reports of inquiry I have mentioned in this paper. Thank you for your attention and goodbye.
Thank you, Dr. Kyriakidis, for your insights into what risk assessment can mean for legal practice and what can go wrong in the event of insufficient precautions. It is now time for the concluding remarks and to close today's conference. At the beginning of today's proceedings, I drew all delegates' attention to the importance of the rule of law in times of public health crisis and emphasized our collective responsibility vis-à-vis the rule of law. I'm very happy to see that all our distinguished guests and speakers have deeply rooted their interventions into justice and collective good governance. The President of the Supreme Court of Cyprus, Justice Stelios Nathanail, referred to the multiple actors of the justice system and to multiple factors affecting the good administration of justice. I would like to briefly give some elements of answers to the series of fundamental questions posed at the beginning of the conference of high relevance to the legal industry. What is the current state of affairs? As we heard today, not least from the Attorney General of the Republic of Cyprus, Mr. George Savvidis, COVID-19 has been a catalyst of change in justice for all stakeholders, I would dare to add. This includes the legal industry as well as relevant public authorities. Examples of this can be found in changes to the law, working patterns, systems and services, but also in human relations. What lessons can be learned from the current state of affairs? The importance of re-engineering the way we work and interact seems to be recurrent. Reforms undertaken are inherent and structural. They are also multidisciplinary, as they entail, among others, the knowledge and practice of management, leadership, entrepreneurship, innovation, and technology skills and competencies. What is the role of the rule of law? The rule of law is central and fundamental for all actors of the justice system, individually and collectively. Respect for the rule of law must include robust considerations of accountability, transparency, efficiency, and fairness to all. This requires at the same time a good dose of pragmatism in the application of the principles of good governance. As the Minister of Justice and Public Order, Ms. Emilie Iolitis, reminded us in her speech, respect for justice is correlated to the country's economic and overall performance. In closing, I would like to thank all of you, our distinguished guests and speakers, for the insightful presentations, and our panelists for providing their own professional views on the justice process and its reform. I would also like to thank all of you for participating and providing feedback on the event. In particular, if you could reflect on the usefulness of today to your professional development and career. I very much look forward to seeing you all again for another edition of the Cyprus Legal Annual Conference.